Good evening and welcome to the Planning Committee meeting. It is now 6 p.m. and I'd like to start the meeting. My name is Mike Fletcher and I will be chairing the meeting tonight. I'd like to remind everyone present that this meeting is being live streamed and recorded for publication on the Council's website. There are no planned fire alarms this evening. In the case of an emergency, please evacuate the building using the nearest available exit. I think those are... And congregate at the assembly point outside the college, which is just over there. So, item 1 on the agenda, apologies for absence. Carly, I know we've had an apology from Councillor Cherry and Councillor Benson is substituting. Do we have any further apologies? Everybody seems to be here, so I'd imagine not. Okay, thank you. Item 2 on the agenda, the minutes from the meeting on 8th of May. I move that the minutes of the Planning Committee meeting held on 8th of May 2025 be approved as a correct record. Yeah, sure.
My apologies weren't recorded, but I did send them, so that's it. Thank you.
Thanks, Councillor. Apart from that, any other comments on the accuracy of the minutes? So with that amendment, are we happy to approve those minutes as a correct record? Brilliant, thank you. Item 3 on the agenda, items of urgent business. I've not agreed any items of urgent business tonight. Item number 4, declarations of interest. Do any members have any interest in any of the items we're going to be discussing tonight that they'd like to declare? Steve. Check if Alan's is working, that might work.
The other button works, that's better. On the 21/009004 Bombers Cafe, in the it says that there were some correspondence, and one of them was from me. So I'll exclude myself from discussing that at the time when it comes up. Thanks, Chair.
Thanks, Steve. Yeah, Steve.
Just let you know that I did have some discussions about Bombers Cafe. Some years ago, they were inquiring about planning permission, and but I've not heard from them for probably 3 years.
So, do you think will that have any impact on your ability to sort of listen to the item on its merits? No, so we'll be fine. Okay, thank you. Right, declaration of receipts. So, does anybody have any correspondence, meetings, discussions relevant to any of the planning applications or enforcement actions to be resolved at this meeting, which they'd like to declare? Aaron.
Chair, I don't know if we should bring it up, but regarding the first item we're going to be discussing on Gunning Road, following the last meeting, we all received an email from the agent saying why we should have the reasons behind why we should have accepted it. I forwarded it on to officers and I didn't respond, but I think it's worth having that on the record that we did receive that correspondence.
Thanks, Aaron. Yeah.
And plus the site visit, of course.
Yeah. Okay, so yeah, everybody get that? Obviously, we will be, to a large extent, disregarding whatever was in that, and we'll be basing our discussions and our conclusions on what we hear tonight, plus obviously what we discussed last time. Okay, thank you. Item 6 on the agenda is planning appeals. Jonathan, could I ask you to present the latest update?
Thank you, Chair. So the decisions for the last month, the full month is April, and we had 4 decisions, and they're all dismissed, which is good news. Another bit of good news, these were all sort of reasons connected with design, so it's sometimes a subjective thing, so it's good that officers are being supported on design reasons for refusal by the inspectorate as well.
Thanks, Jonathan. Anybody got any questions around the appeals update before we move on? No, great, thank you. Which brings us, to our recommendation on that, which is to note the report. So is everybody happy to note the report we've just been given? Fantastic, thank you very much. So that brings us in turn onto item 7, Gunning Road, land between Gunning Road and Globe Industrial Estate. So it's yourself again, Jonathan. May I ask you to present the report?
Thank you, Chair. Excuse me. So this application was before members at the April Planning Committee meeting with a recommendation for approval. The recommendation for approval fell, and members required an updated report from officers to address the concerns raised during the meeting. So the site is in front of you on the screen at the moment in red. It lies directly on the boundary of the Globe Industrial Estate to the west.
Sorry, Jonathan, can I just check? I know a couple of people are in for that. Can you hear what's being said, yeah? Yeah, lovely. Okay. Thank you. Sorry, Jonathan.
Thank you, it's fine. And the residential area to the east. A site visit took place last Friday with members visiting the site to see the circumstances on site. So that's the red line site area again on the aerial photo. It's the southern part of the buffer zone between the two land uses. That's another red line that shows the applicant's site ownership. So the application site is in red and the blue line is the rest of the area owned by the applicant. And that's the proposal. So it's a 2-storey building for a small-scale, quiet commercial use. For example, a type of, perhaps something like an accountant, a bookkeeper, a quiet type use that would be suitable within a residential area. That's a street scene, so you can see to the right-hand side of the picture, the houses on Gunning Road to the rear. That's a picture of the application site, so it's to the left of the garage block there and stretches approximately to where the hand is on the screen. That's looking to the east, so you can see the properties in the far distance. So the application is proposed for a small commercial unit. It's acceptable in principle. Matters of detail such as design and layout and highways impact are all considered to be acceptable. If I just refer you back to the site plan. So at the last meeting, reference was made to the buffer zone between the properties on the east and the commercial area to the west. And it is correct that that was shown as a buffer zone when the estate to the east was given permission in the 1990s. As discussed at the last meeting with the legal officer, just because the site was designated as that form in the planning application doesn't mean a subsequent planning application can't be approved for a different use. And as members will note from the report, the application site itself is actually designated in the local plan as a commercial area. So the principle of development for commercial use is acceptable in that location. Since the previous report, 2 additional conditions have been added. So one of those is in relation to land levels to ensure that the development sits suitably within the street scene, and that should allay some of members' concerns about the impact on the properties to the east. And there is also a condition, an extra condition in regards to acoustic fencing, so that should provide some further comfort for residents and members that the proposal will not have a detrimental impact on neighbour amenity.
Thanks, Jonathan. So, members, any questions for Jonathan on what you've just heard? Oh, sorry, 2 seconds. If I can just bring in Ash.
Yeah, thank you, Chair. So just to confirm, so this came to committee previously and we've done site visit, but any member can still vote on this item. So if you need any points of clarification, just please do pick them up at the Q&A with John now.
Thanks, Ash. So, yes.
Yeah, thank you, Chair. Sorry, obviously that is good news that all members could vote. Is that a rule change, Ash, Mr. Barker? Because we never used to do that. You'd have to be present for both meetings. So just clarification.
Ash will fill you in on how we've arrived at that.
Yeah, so myself and Helen, the AD and legal, reviewed the Constitution. the Constitution doesn't specifically define that members cannot vote if they hadn't voted previously, or they weren't on the committee, or even if they hadn't attended site visit. So because it's silent in that regard, Helen and myself are content that members can vote as long as they've been presented the same information from those that were presented previously, which John's articulated, but also any information on the site visit that's pertinent. We need to make sure members are aware of that, which I'm confident they are, but nonetheless, please do ask any questions now.
Okay, yeah, I wasn't sure that was the case. I thought it was quite specific in that area, but I'm happy to go with your professional advice on that one. Thank you.
So, Tom, was there a question on the...
Well, it was just, I think, Councillor Jones, then Councillor Lydiard. No questions from me. Thank you.
Okay, so sorry. Right. Steve, I'll hear you first and then Roy, if that's okay.
Thanks, Chair. Just for clarification for those people that didn't go to the site meeting on Friday, can you confirm that there wasn't any problem with the big lorries coming around the corner there, and also that there was only about 3 feet of disturbance to the view from that first house?
Okay, yes, so thank you, Councillor Lydiard. So yes, when we attended the site visit, there were some HGVs which came out of the site opposite. So this is site access. So some HGVs did exit site and come across and turn right along Towers Road. None of those HGVs were in a position where they entered the site, so there was no overrun within the application site itself. So there's no problem with the development within the boundaries of the site causing harm to existing HGVs, and there wouldn't be a detrimental impact on the existing use of the site opposite. And just to confirm, in terms of the site plan, so the proposed building is roughly in line with the back of the garage block, which I'm indicating with the hand on the screen. So it sits in the middle, so it doesn't go beyond the garden of the residential properties behind.
Thanks, Steve. Roy?
Thank you, Chair. That's one of the things I wanted to clarify was whether or not, because obviously I was not on that previous committee, but I've paid a site visit. Just wanted to... Is it the one where the boarding is up, Jonathan? There's the black boarding. Is that the actual area we're looking at? Yeah.
Yeah, so the right-hand side of the building is approximately here where I'm marking with the hand, and the left-hand side of the building is approximately here where I'm marking with the hand. So it goes across the middle of the site in proximity to that garage block, but yeah.
And also, what usage is it going to be? You know, should we say it's going to office? Is it office space we're looking at permanently?
So it's a Class E use. There is a condition on the application, so condition 7, so Class EA and EC, and those are sort of small scale, quiet commercial uses, things that would be suitable for a residential area. So it won't be a takeaway, it won't be a hot food takeaway, it won't be something where they're fabricating materials, so they won't be generating noise or smells or disturbance. It's a sort of quiet office-based use.
Thank you.
Thanks,
Roy. And Kathy, you're next.
Yeah, I'll just to go back to the HGV issue. We were there, so there were HGVs that came round to the right, and they didn't go onto the site as such, but they did mount the pavement, which, there's about 3 of them we saw. And I brought this up at the time, but there was trailers parked on this side of the other side of the road, making them take a very wide turn. So I just want, and I did bring up if there was any chance of putting parking restrictions on this side of the road.
Thank you, Chair. I wasn't at the site meeting, but when I did go myself, there were actually a number of lorries went in and out the site that I actually took pictures of, at the time, they didn't mount the curb. So I guess maybe those trailers were causing the problem, or maybe the drivers were just being a bit overcautious, maybe in the way they were manoeuvring. We could potentially introduce restrictions, but within the current traffic management budget, I wouldn't have thought there would be the money to fund such a scheme. If anything, we would potentially be looking for the applicant themselves to potentially fund the scheme.
Thanks, Kathy. Anybody else with any questions? Steve.
Thanks, Chair. Just two things. One, nobody told me that there was a site visit. Just thought I'd mention that because obviously I got left off the list. So, and the second one is, have we made any progress with the fact that, as we discussed last time, it was that boundary was put there and the giveaways in the title as a buffer zone. So it was put there so that it was left to grow wild, but it offered some protection to those houses. And that's what apparently we're going to get rid of if this is accepted. And then my next question would be, so what then is to stop the rest of that strip that runs right the way up there being developed?
Thank you. So, yep, the site was part of the buffer zone for the residential development from the 1990s. I think in terms of this part of the site and further parts of the site, this area, there's a sort of point made in the report that this red-lined area is very flat compared to the rest of the buffer zone, which slopes up and has a sort of hut within it. There is a sort of bigger mound within it. So the purpose of the buffer zone, the southernmost point, isn't as defined as it is further up. And because the site itself doesn't immediately back onto any houses, there is arguably less of an impact on it being a buffer zone than the area further up, where it does shield the bigger buildings, where they're creating more noise and disturbance. And I think it could potentially be thought that if you had a solid two-storey building, that would deflect some of the noise from the wider estate, which the lower level fence as it exists at the moment doesn't. And there are, as I said, there are two new conditions. So there would be acoustic fencing put up around the site, which would also benefit residents. And we've put a condition on ground levels to ensure that the building does sit as low as it can relative to the surrounding street seen on Towers Road. So it shouldn't create an impact in terms of neighbours in that sense.
Thanks, John. Thanks, Chair.
Thanks, Steve. And sorry, it sounds like the curse of the co-opted member is striking again. So we need to look at that. Building on Steve's question, John. So we have a buffer zone and we're talking about building on the end of it. In your view, what impact will that have on the effectiveness of the rest of the buffer zone? I think this is probably what we're trying to get at.
So the existing area that we've seen on the plans is relatively level compared to the rest of it. So it's not. There could be further applications in the future for people to look at other parts of the area, but this site is the only part of the buffer zone that has direct access to the public highway. If this scheme was implemented, then it would effectively stymie anyone heading up the buffer zone along this route. There are a number of other sites to the west which do adjoin the buffer zone, but each case would have to be looked at on its merits, and this one, the built form, doesn't immediately adjoin the back of the residential properties, whereas on some of the other sites, if you went further up, they would immediately join the back garden. So the actual built form on this one would be very different to what you would get if you went further north.
So if I understand it rightly, the rest of that blue area, what you're saying is if they were building at the bottom of it, you don't believe that would encourage building on the rest?
I think the layout and is quite different because this one's sort of discreetly located on Towers Road, whereas the rest of them would be sort of easternwood extensions of existing plots. So I think it's different from the rest of them, and characteristically it sits more with Towers Road, whereas the rest of the buffer zone sits behind the properties and the commercial premises. So I think there could be a distinction made.
And would it set a precedent for building on the buffer zone?
I think because of the differences in the site, this one, and areas further up, I think it would be the circumstances wouldn't be the same if you went further up.
Okay, thank you. And just one final question. One of the points we raised last time around was that I think there are 2 parking spaces, and we felt that was a little bit light for even a commercial enterprise. Obviously, the site visit showed us that there are other spaces on Towers Road. What was the view, I suppose this one's probably to yourself, Julian, what's your view on the likelihood of there being sufficient parking for a business like this, which is likely to have, say what, probably a couple of cars belonging to the business and 1 or more belonging to clients?
Thank you, Chair. I, like you, visited the site, but obviously not on the times that you visited, specifically, obviously, to look at it at other periods of time. So I particularly went at a busier time. The same thing when I went, there were several spare spaces. I mean, those spaces were specifically created along Towers Road to take vehicles off the road from a lot of the developments along there, and with the spare capacity in the road, I don't see that the 2 parkings, we could refuse the application on 2 parking spaces. If it went to appeal, that an inspector would highlight the fact that if they visited it and there was spare capacity. We have this similar problem, I would say, with housing developments, you know, where there's an argument about 1 or 2 spaces, and in appeals the inspector's gone, well, there's plenty of parking space on the highway. They don't necessarily see a reason for refusal on parking alone. And also, it's very difficult to refuse just on parking. You'd have to look at the safety implications of not providing the appropriate level of parking. And as there is spare capacity, there obviously is the ability to park off the carriageway, but on the highway, and therefore there isn't a severe reason for refusal on parking.
Thanks, Julian. So basically what we're saying is that in looking at whether the parking is sufficient, we're not just looking at the parking provided with the development, we're looking slightly more widely at the parking in the immediate area.
Yeah, I mean, the classic is, you know, the conversion of a garage to residential, or a gym or something, and the fact that you're reducing the amount of parking, and you've got to weigh in the balance of losing that parking space. If it was an area where there was potentially a severe parking problem, then we may have a different view on that. But the loss of, in those cases, the loss of one party wouldn't be severe. So we're looking in the same sort of balance in terms of, there is parking there on street available, so it would be very difficult to potentially refuse it just purely on parking.
Thanks, Julian. Alan.
Thank you, Chair. Going back to the elevation pictures that you had up earlier, if you can pull them up, please. So the middle one to the right shows a parking area underneath within the building.
Yes, the parking areas are in a sort of undercroft, so there's tandem parking spaces underneath the building, that's right. Yeah.
So there'll be so on the original plan, how much of that area will the building take up? The whole area, or is there any parking to the left, to the north of it? On there, is that all building?
The building is sort of approximately to where the hand is on the picture, so it sort of covers sort of a third at the front of the site, and the rear section is to be left open, and that will create a sort of break between the neighbours, so there's no building in effect behind the neighbours.
Right, so the car entry is via the industrial unit or Tower Road?
So the cars will come off Towers Road
And across
enter
the
the site.
pavement
Yeah.
into it?
Yeah.
Thank you.
Thanks, Alan. Any more questions? Steve?
Thanks, Chair. It might be me not understanding, but on that plan, what's the line running through the centre of the site?
So
Is,
yeah.
go on, sorry.
So yeah, the line, as you said, it does run through the middle, and that is the fence in the middle of the buffer zone. So if you look at look at the photo, there's a fence in the middle of the area which runs up. So that would be the highest point in the middle, where the land is banked on either side.
Thank you.
Thanks, Steve. Is that it for questions? Great. So what I'd like to do now is move on to your thoughts, pro and anti. So, Tom, do you want to kick off?
Thank you,
I
Chair.
said, do you want to kick off? Do you want to go first?
Cheers. Thank you. Thank you. Right. So obviously we did spend quite a lot of time at this the last planning committee meeting on this. Obviously we had two reasons for refusal. One was parking. One was the subjective view as to whether we should be encroaching on the buffer zone. I'm still not happy with the parking. Obviously, being a ward councillor, I know the area quite well. Having said that, I also am aware that if we was to refuse on grounds of parking, that it is likely that the impeding inspector would probably look at the highways officer's recommendation that it's okay. So whilst I'm not happy with it, my own personal opinion is I'm happy to drop that as a reason for refusal. However, the subjective view as to whether you should be encroaching on a buffer zone is still present, and the developer respectfully is clearly trying to, squeeze a development on this small patch of land. I think it does set a dangerous precedent on the buffer zone. It doesn't necessarily have to be a building in the future. There's a lot of warehouses that back onto that. They could easily put in an application for additional storage, which would be no building but an encroachment. So for me, I appreciate the officer's report. I understand how the officers come to that recommendation. In a sense, I don't disagree with that opinion based on the rules around the MPPF, but that planning is subjective. That buffer zone I don't think should be increased. So for me personally, I'm still of the opinion that the subjective view is that we shouldn't be building on that buffer zone. Thank you.
Thanks, Tom. Who's next? Anybody? Anybody who went on the site visit, I'd be particularly interested in. Okay, so Steve, then Roy.
Thanks, Chair. I have to say I echo Councillor Kelly's sort of view that it doesn't have to be built on. It's a relatively small patch of land and it performs a function that's why it was put there in the first place. So what's changed, I don't understand. So personally, I still, even if the parking is okay, I still think that the development on what was designed as a buffer zone, where there's a fence in the middle of it that delineates the centre of it, and generally a fence is a boundary, so you're going to lose that too. So personally, I'm still not happy with what's come up. Thanks, Chair.
Thanks, Steve. Roy.
Yes, I agree with that, Chair, and also, the parking. It's a busy estate. It's a very busy estate. That is an industrial estate. You can see cars parked here, there, and everywhere at times. Maybe when you went down there, Julian, that was a good time, but most times you go down there. I've got some friends that work in companies down there, and there's always issues with parking. So. And I think that buffer zone was there for a reason. So I can't see why we can't keep it as a buffer zone. Thank you.
Thanks, Roy. Aaron, then Steve.
Thank you, Chair. I was on the site visit on Friday, and a part of the site visit we went on Towers Road, and we went round to Gunning Road. So we saw it from the resident side and the actual industrial side. And from the industrial side, it is noisy and quite lively. But going round to Gunning Road, it's actually quite relaxed, quite that quite relaxed, apart from the scaffolding men we saw trying to put up with the music that day. So I am concerned removing this buffer zone, we're going to end up having more noise pollution affecting the residents. So I'm still on the same opinion, same as Councillor Kelly.
Thanks, Aaron. Steve.
Thanks, Chair. I mean, I sort of agree with everybody else that it is a bit of a quart into a pint pot, but it's got a garage. I know there are parking problems up the road. I know there's big lorries coming round, but I can't find any material reason to turn it down. So I shall be voting for acceptance.
Thanks, Steve. Anybody else want to contribute to the debate? Okay, so we're looking at, I think, two elements to this. The parking, as we say, the parking is, I don't think any of us were entirely happy with the on-site parking. I think the site visit has demonstrated that there are occasionally alternatives, by no means guaranteed. And I think the point's been made that we would find it difficult to refuse on the grounds of parking. So if we said to take the parking side of it, I think that would be a rather difficult case to make. If we go back to the other one, though, the buffer, and we seem to be quite clear that there will have been a reason for that buffer. We don't, I think, yet see quite how building this building on the edge of the buffer improves it. I think it's fair to say that from what we've seen, the building doesn't. It's being built where there isn't necessarily anything on the other side. So the building in itself won't necessarily cause problems over what's there now, I don't think. However, there is the question, which seems to be concerning most of us, that if you build here, does this then make more of a case for building elsewhere in the buffer zone? And at what point does the buffer zone basically collapse in on itself? So I think this is where we seem to be coming to, that we, from the sound of it, still remain unconvinced that whatever its validity under the plan, and I think, Ash, I know you'll want to come in on the plan, I would guess. We still have a concern that, given that that buffer zone was put in for a reason, we still don't quite understand how building on the last chunk of it improves the situation. I think that's, hopefully I'm summarising reasonably what you're saying. Yeah? So that seems to be our point of view. I don't know if Ash or Chris, you want to come in?
Yeah, so I think members of, obviously the second time it's come to committee, you've had obviously the Office of View, so I'm not going to sort of repeat that. It's quite clear what our position is. If members are sort of minded to go down a certain route, that, you know, that's within members' gift. I think from what I'm hearing, it's particularly around the buffer zone rather than the sort of car parking element. But I will ask my colleague Chris just to come in to give some reference to the National Planning Policy Framework on car parking, just so you can hopefully sort of close that one down.
Hello, yeah, just a relatively quick point, just regarding what the NPPF says on refusal on highways grounds, and the NPPF is obviously a material consideration for members. It's that development should only be prevented or refused on highways grounds if there'd be an unacceptable impact on highway safety, the residual cumulative impacts on the road network, and that following mitigation, that would be severe. And severe is obviously a high threshold. It's not defined itself in the NPPF, but it's relatively clear from the officer's report that that threshold they don't consider is met. And I don't know if Ash is going to pick up on the development plan, but just to note with respect to that is that the buffer zone, and I think Mr. Kozelko spoke about this last time it was before committee, the buffer zone is something that's set out in this 1990s permission. Since that point, you've got the development plan that, the core strategy succeeds, not replaces, but that permission. Within the core strategy, this is an area for sort of light commercial use. The starting point in the 2004 Act is that you should go with what the core strategy says. You need to consider that the impact of allowing this the detriment on the amenity of the surrounding areas, which is what I understand your reason for refusal largely is, outweighs the effectively presumption in favour of this light commercial use, which is set out in the core strategy.
Yeah, so that was relayed to members previously. So I think you're clear on the opposite position. I think we are going to struggle to sustain this, but nonetheless, obviously, you've had all of that information, so I'm not going to repeat that any further.
Anybody got any questions on what you've just told? Oh, apologies, John.
I'll just come in very briefly. The applicant has raised, I think it was probably in the email he sent to you, that there have been 2 previous applications on the site. So there was the 2022 application for a similar commercial use, and that was accessed through Gunning Road and through the properties, through the parking area on Gunning Road, and that was refused by members on the access issues arising through the parking court and the amenity issues arising from that parking, and that appeal was dismissed on the grounds of the access and neighbour amenity. So there's no reference in that recommendation for refusal by members of the buffer zone or the impact on neighbour amenity. The second application from 2023 was for a residential property in this location, and that was refused by members at committee on the basis of the principle of a residential property in a commercial area and a lack of a Section 106 agreement. And that was also dismissed at appeal, but that was only dismissed on the principle of the residential use in the commercial area. So again, there was no consideration at that time of the buffer zone and the impact on neighbour amenity from the building itself. So I was just highlighting that for members as well.
Thanks, John. It's a fair point. I think it's a statement of the obvious. It's a different committee with different individuals. And I think within our own group, I think we've been fairly consistent. So I would be comfortable, at least, that this group is being consistent. I appreciate your point there. So it appears that we are in effect saying, on the one hand, we have the current core strategy saying you can build. Sorry, folks, I'm just trying to lay this out for you. So we have the core strategy that says this is acceptable building in this area. Against that, we have the impact on the buffer zone, and what we are saying, what we're effectively saying is you start chipping away at the buffer zone and you erode the protection between the... So that's basically our issue, you know. And as the point, as Chris has said, we have to decide as a group, does the fact that it's allowed outweigh what we feel to be the potential impact on the residential areas? And I guess I'll push that one stage further. Potential impact, not so much of this building, or what we seem to be talking about is potential impact of what this building might open up in future. And I need to say that because we really actually need to be talking about this building. So I suppose the direction I'm giving you is that's what we need to be weighing up. Impact of this building on the surrounding area versus the fact that it does meet the terms of the core strategy. Now, with that in mind, and it's a straight weighing up job, that doesn't necessarily push you one direction or the other. It's a case of saying, which do you consider more important? What I will do is move to the recommendation and see if that stands or falls, then we can look at what we do next if we need to. So, apologies, I'm finding too many bits of paper. So the recommendation is that the Chief Planning Officer be authorised to grant permission for this development, subject to those items set out in section 6 of the report. That is the conditions, including the 2 new ones that John has put forward. So that's the recommendation. Do I have a proposer for that recommendation? Steve, thank you. Seconder? Okay, to get things moving, I will second. Right, so all those in favour of the recommendation, please. Three, yeah. All those against? So the recommendation is rejected. Ash, can you give us your thoughts on where we go next?
Yeah, so in line with the Constitution, if that recommendation falls, just need a member committee to put forward an alternative motion. Rather than kind of reinventing the wheel, I'll read out the what members were minded last time, which stated siting of the development within a buffer zone and the impact of the proposal on the amenity of the neighbouring residential developments. That was the sort of prime reason. There was also a reference to traffic impact, access and car parking, which from what I've heard, as members are not moving forward with. But ultimately, we'll now need a member to put forward an alternative motion to vote upon.
Sorry, I think it was by a very short head. It was Aaron. I could be wrong.
Tom's got experience in this. I'd give way to Tom.
Tom.
Yep. Thank you, Chair. Thank you, Aaron. Yeah, so I would like to recommend refusal, and I would like to use the alternative motion to refuse on relation to the subjective view of this building in the buffer zone. I know they have been refused previously, and I think the buffer zone hasn't been raised in the past. That doesn't necessarily mean to say it isn't an issue in this particular scheme. Had it been raised in the past and it went to appeal, and the inspector said, you can't, we're not happy with the buffer zone, you can't use that, then yeah, ultimately I wouldn't be in front of you now saying, let's use the buffer zone. At the end of the day, it really comes down to, on appeal, what is the subjective view of the judge. So, yeah, keep it straightforward. The parking, I'm still not happy about it, but I accept the judgment of the highways officers on this particular case. Obviously, the judge will probably take a similar opinion on that as well. So, keep it simple, refusal on the grounds of the buffer zone. Thank you.
So if I can summarise, I think, yes, so the proposal is to refuse on the basis that on the basis of the siting of the development within a buffer zone and impact of the proposal on the amenity of the neighbouring residential development. Apologies, can't find my glasses today, so I am blind as a bat. Right, that is the proposal. Can I assume that you're proposing it, Tom? Can I have a seconder? Aaron. All those in favour of that proposal? All those against? Okay, I think that proposal has passed. Thank you very much. Right, that moves us on to item 8 on the agenda. This is the tree preservation order for Grices. Jonathan, just for a change, it's yourself presenting the report.
Thank you, Chair. This application is deferred from the previous meeting to allow 2 additional reports to be made public that the applicant had originally requested be confidential. Those reports have now been made public, so the item is back for reconsideration. I'll just run briefly through the presentation from last time. So the proposal seeks to fell a preserved oak tree within the garden of Grices in Horndon-on-the-Hill. The reason for this is the applicant from number 7, Saffron Close, has put forward an application to fell it because they consider that the tree is causing damage to their property. So a report provided with the application considers there is severe damage to the property and that if the tree is felled, the repairs that would need to be undertaken would be in the region of £15,000, but if the tree is retained and underpinning is taken, they would be estimated at £45,000. So the report from the Landscape and Ecology Officer indicates that while the tree is of value, he doesn't disagree with the findings of the professional report submitted. There would be likely ongoing costs further as well if the tree remains, and there could potentially be implications for other properties in addition. The liability to pay compensation could encompass the reasonable costs of carrying out underpinning or other requisite requirement works, and it may fall to the council if the application is refused. On the basis of the information available, it is therefore recommended that permission is granted.
Thank you, John. Right, we have a statement of objection from Peter Woodard. Mr. Woodard, if you're there, would you like to come down and read us your statement of objection? Thank you. You'll have 3 minutes, and it's the button on the right that seems to make the difference.
The geotechnical report, in a note on page 2, states, at the corner of the property's extension, there doesn't appear to be an existing foundation. This is the corner of greatest subsidence. Surprisingly, no attempt was made to find out the full extent of the missing foundations. Both trial pits are but a later addition to the house. No attempt has been made to determine the adequacy of the foundations of the original building. An earlier EAR for a neighbouring house reported the foundations have been built at a relatively shallow depth. That application was refused, no trees were felled and the property was underpinned. The tree report states, if after the tree has been felled there is little improvement, this may mean that the situation cannot be rectified by arboricultural means alone. So the tree would be felled, the conservation area devastated, and then underpinning is done anyway. In other words, felling is a gamble, so why is there no indication of the odds? So taking account of the great distance of the tree from the building, the failure to find live roots, the inadequate foundations, the extent of the damage shown in the photos, I suggest that the chance of a successful outcome by felling the tree is vanishingly small. It is almost certain that underpinning will be needed anyway, so a comparison between the costs with and without underpinning is meaningless. At the May meeting, one member said it is a shame that a monetary value cannot be put on this tree. Actually, it can. The capital asset value for amenity trees system is regarded as one of the principal methods of tree valuation in the UK. Using the CAVAT system yields a value for this tree of £203,000. This makes the total cost to the insurance company and the community of felling the tree and repairs of £233,000 compared to £180,000 for retaining the tree and underpinning. So when the value of the tree to the community is considered, underpinning is the cheaper solution by £53,000. I have very carefully examined all the evidence in the reports accompanying this application, and proof that the tree is the cause is simply not there, and without that I cannot see why the council would accept any financial liability. The officer's report does not follow the evidence. This tree has been iconic to Horndon for well over 100 years. Please respect our heritage and the conservation area, and do not be like the despised vandals who cut down the tree from the Sycamore Gap. Do the right thing for your community and reject this application. Thank you for listening.
Thank you, Mr. Woodard. Members, before we let Mr. Woodard go, do you have any questions, factual questions for him? Jackie.
I don't have a factual question, Chair, but I'd just like to say thank you to Mr. Woodard for cutting short his holiday to come here this evening and read his statement.
Thank you, Mr. Woodard. And I think we can let you go. We have a further statement of objection from Ward Councillor Barry Johnson. I don't think Councillor Johnson is here, is he? Oh, sorry, Barry. Like I said, wrong glasses. Would you like to come down and read your statement, please? Sorry about that. Right, Councillor, you have 3 minutes, and you know how to operate that thing anyway.
Thank you, Chair. I'm really not going to be able to add too much more. Mr. Woodard's been very eloquent, and a lot of the facts were in his words. But thank you for allowing me to speak again against the felling of this iconic tree. I'd just like to reiterate that the strong feeling around this tree being an integral part of the village should really not be underestimated. And until such time as conclusive evidence is provided that this tree is the cause of the subsidence, then I've asked the committee to grant it a further stay of execution to allow such evidence or proof to be shown, as that is certainly not proven within this report. Earlier reports quite clearly indicate that the foundations of the said property suffering from subsidence were inadequate, and more recent reports suggest that live root samples would indicate the cause, yet no such live roots were found. I believe the only real cure for subsidence is underpinning, but I cannot understand why this tree is being targeted as the cause of the damage without proper evidence. And I believe it would be a failing of the council to fell the tree only to establish that the property's inadequate foundations were actually to blame and underpinning made necessary anyway. After all, this was done successfully to a property in the same vicinity. I understand the council fearing the refusal to fell this tree would or could render it liable for underpinning costs, but I do not see any evidence to suggest it is the tree causing the damage any more than the inadequate foundations. So please grant villagers' wishes and vote against officer's decision and allow this wonderful tree to grace the village for many more years. Thank you, Chair.
Thank you, Councillor. Again, members, do any of you want to ask any questions of a factual nature? I would like to ask one of yourself, Jonathan, in relation to what the council has just said. So this other property, have we looked at, I appreciate that you look at each one on its own merits, but have we looked at this other property in terms of understanding what the proximate cause was there?
In terms of this application, we've only looked at the information for this property, so we haven't looked at any further properties on Saffron Close, no, as part of the consideration of this proposal. We can only consider this application on the basis of this property. Just wondered if I could quickly pick up a point from the Speaker's statement. So I sent a copy of the Speaker's statement to our arboriculturalist today. He said that he understands that the London Tree Officers Association do use the CAVAT analysis for sort of cost of trees, and it's not well used in Essex, and the council itself hasn't adopted the CAVAT sort of system of assessment and has no policy about it, so we need to be careful. I appreciate that the resident has done some research into this, but we don't have a policy for using that for determining applications, so I just wanted to let members know.
Thanks, John. Thank you, Barry. Appreciate your time. Right. Councillors, do you have any questions for Jonathan on what you've heard so far? Oh, sorry. Apologies. Just quickly like to get legal in. You will find this quite useful, I think.
Hello, this is a slightly novel application to come before you, and I thought it might be useful to set out what you're determining and the implications of either approving or rejecting it. So, starting point is a TPO is put in place where it's expedient in the interest of amenity to make provisions for the preservation of trees. If a TPO is in place, sorry about that. If a TPO is in place, if you chop the tree down, you're committing an offence. The committee here are being charged with deciding whether or not to revoke the protected status and enable the removal of the tree, but not to authorise the removal of the tree itself. The council don't own the tree, they don't own the land that the tree is on. Essentially, you are being asked by the applicant to make the necessary but not sufficient step to remove the tree. If the TPO is revoked by you today, but the owner of the tree refuses to allow it to be chopped down, that's a matter of private law between the owner of the tree and the person who wants it chopped down. Simply because the tree is revoked doesn't mean the tree comes down automatically. In terms of what you need to consider when making your determination whether or not to revoke a TPO, there's not a tremendous amount of authority on the point, but broadly you do have to consider the amenity value of the tree and such other matters as you consider relevant. Obviously, the officer's report flags as a particularly relevant consideration the potential cost to the council if the TPO is not revoked. And that's because both the Town and Country Planning Act 1990 and the relevant tree protection regulations provide that if a person establishes that loss or damage has been caused or incurred in the consequence of the refusal of a consent, so if the applicant could demonstrate that by refusing permission to revoke the TPO, loss or damage was caused, i.e. the subsidence had got worse, they would have a claim against the council. The test would be on the balance of probabilities, i.e. 51%. Is it more likely than not that this tree is the cause of the subsidence damage to the property, and is the sum that they're seeking, roughly £45,000, is that a reasonable and foreseeable consequence of the subsidence? At present, as I understand, the council don't have any competing evidence to contradict that put forward by the applicant. So I think it's just important to flag, I guess, the 2 points. If you were to approve, that's not the same as saying the tree comes down. It's removing the legal protection in place that prevents it. If you are to reject, it potentially opens up the local authority to a claim for compensation being brought by the owner of the property to which the subsidence damage is being incurred. It would be for them to demonstrate that the tree is the cause of that, and that your, if you were minded to do so, refusal to revoke had also contributed to that. And the sum that the council will be liable for is that currently set out in the officer's report, which is about £45,000, plus potentially legal costs if it went to a tribunal.
Thanks, Chris. A lot to chew over there. I mean, effectively, yes, if we agree to revoke the TPO, we're not actually saying this tree can come down, but we're removing the protection that currently exists for it. That's a fairly significant step towards cutting it down, I would suggest. Okay, we'll move on to debate shortly, but firstly, any questions? Jackie.
Lovely, thanks, Chair. The EAR is 5 years old, is it not?
Yeah, the application was from 2021,
Yeah.
so the costs could have increased since then and
Okay.
probably would be likely, yeah.
So it's not really the cost that I'm really too concerned about at the minute. The report says that the property was at imminent risk of collapse. And that was 5 years ago, and the house hasn't collapsed. It's still standing. So I would have expected to have seen further structural damage between then and now. So has any further subsidence been identified since then?
The application is being considered on the basis of the information that came in with it at the time, so there hasn't been a further formal submission about any further details about any further damage to the property. But yeah, it's a point in time from 2021, so the costs could have risen since then.
Okay. Thanks, Chair. So just one more. It's not a question really, but it is a question. If you were to book a holiday in a hotel and you were told it was coming down, it's imminent danger of coming down, you wouldn't book it, would you? Because imminent means imminent. It's 5 years on. The house is still standing. The words imminent collapse, that's quite an extreme statement to me.
Thanks, Jackie. I suggest that that's actually probably quite a useful point to come back to when we get to the debate stage. Okay. Kathy, you're next.
Thank you. I just wanted to ask a question about the previous case, which I think was 2013. And in that case, the felling of I think it may have been one of the other trees, was refused, and the underpinning was carried out, which presumably successfully. Was there any, was the council sued over the refusal at that stage?
Sorry, I don't have those details to hand, sorry.
Okay, all right, thank you. But presumably, well, we don't know.
But, Councillor, in response to that, if that is something you're considering it should be for this application, councils do get pursued for legal action. So there is case law where councils have been pursued for costs recovered as a result of refusing applications to fail.
But not on the previous.
Well, I think John's answered that, but in terms of the point being around the costs, they are relevant in this application for your consideration.
Thank you both. Any further questions? Steve?
Thanks, Chair. Jonathan, I'm slightly bemused. I missed last month, obviously, so you may have covered this. But the applicant is to remove the TPO isn't the person that owns the tree. Is that correct?
That's correct, yeah.
So is the applicant an insurance company?
The applicant is listed as the occupier of Saffron Close, so the 1970s properties just to the south of the site.
Okay, so it's the person whose house is being affected, not their insurer.
The application is being made by
the individual. The
yes,
household.
it's the individual of number 7 Saffron Close. Yeah.
Thanks, Jonathan.
Thank you, Steve. Aaron?
So I suspect that the TPO was put on the tree by the owner. If we're going to remove the TPO, I don't see that being correct. Is that legal? If it's somebody else owning, somebody else asking to remove a TPO on a tree they don't own.
We have somebody here who can answer that one.
Yes, is the gist. It's not the owner that puts in place a TPO, it's the local authority. So it may have been that there was an application made by the owner of the tree and the property at some time in the past to make a TPO. Any person affected can effectively apply to revoke a TPO. It's for the local authority, again, to determine whether or not they should revoke the TPO. There's not a legal principle preventing another person from applying to revoke the TPO.
Yes, Aaron.
So with that in mind, how would we be legally obliged to pay fees if we object this, if we don't own the tree ourselves?
Yeah, so there's a couple of points on this. The regulations regarding compensation for tree protection orders, whether you make one or you refuse one or you make a variation to them, are quite, I think it's fair to say, unfairly worded and broad in their terms. So just setting them out on as they're effectively completely read. If a person establishes that loss or damage has been caused or incurred in consequence of the refusal of any consent, agreement, or approval, they're entitled to compensation. So if the TPO isn't revoked, the tree can't be chopped down without the person doing it committing a criminal offence. It is the applicant's case, and the only evidence as far as I'm aware that's before the committee, that if the tree is not chopped down, the subsidence damage will get worse. Therefore, their argument would presumably go, the council, by refusing to revoke the TPO, have prevented us stopping the subsidence or prevented us from avoiding to incur significant additional costs of the underpinning.
I'm sorry, Chair, I'm really confused here. We've got a owner of this tree who's not even the applicant. We've got somebody else putting in the application for this, asking for this. As we've previously said, it might not even come down if we agree to this, but then if we object to this, we could be held liable and this does not make sense at all, one little bit.
Can I attempt to try and summarise what I've heard? So my understanding, let's for a moment assume that the applicant is right. Then is right that the tree is the cause of its subsidence. It's in our gift to revoke the TPO or not to. So if we were to refuse to revoke the TPO, then the applicant, that's it, end of. You can't, there's no further conversation about trying to take down that tree. As I understand it, if, as a result of our saying no, and as a result of the applicant being able to prove that the tree is the problem, then we would in effect have played a role in making the situation worse. Does that make sense? Is that, Chris, is that basically...
That's basically right. I suppose the only other point to note, there are defences available to local authorities if a claim for compensation is brought. So materially they are if the loss or damage wasn't reasonably foreseeable at the time of the refusal, so today. Obviously, the loss or damage that's being intimated is subsidence and the cost of underpinning, so it's unlikely you'd be able to make good that defence. And also, if the loss or damage was reasonably foreseeable to the applicant and attributed to their failure to take reasonable steps, so potentially the point regarding the foundations being inadequate could be a defence raised by the local authority. The difficulty today in taking a view on those positions is that the local authority itself doesn't have evidence in place to support such matters. Were a claim to be brought, as the chair's quite rightly set out, it's for the person bringing the claim to demonstrate on the balance of probabilities that the tree caused the damage, that the council's refusal to revoke the TPO caused or contributed to that. They have to prove on the balance of probabilities. At the moment, the only evidence before the committee is that presented by the applicant, and their evidence, which the council's officers don't disagree with, says that on the balance of probabilities, the tree is causing the subsidence.
Just one final one, Chair. In Mr. Woodard's statement, he put down the deprived vandals who cut down a tree from the Sycamore Gap. If we remove the TPO on land that the applicant, we specifically, aren't we just allowing them to do it with no legal recourse? This is where I'm getting from this.
Sorry, I guess to chip in on that, the removal of the TPO is, I think, as I said at the outset, it's a necessary but not sufficient step for the removal of the tree. The local authority doesn't have any, or the local authority's powers relating to the tree are limited to trees generally that aren't within their control, the making or revoking or amending of TPOs. If the TPO is revoked, it's no longer a criminal offence for someone to chop it down. The owner of the tree, if, say, the applicant or any person came on and chopped it down, the owner of the tree would more likely than not have a legal claim against them. So it's not that by revoking the TPO, you're leaving the tree to fend for itself. Not every tree has a TPO. It's an important point to also make.
So in essence, it changes from being a criminal offence to a civil offence if it were to be done without due agreement.
In broad terms, there's potentially arguments that going onto the land without permission and chopping down a tree would be criminal damage. But the point about the removal of the TPO just means that it's not an explicit criminal offence to damage this tree. There may be other criminal offences committed if the tree was nonetheless chopped down without the consent of the owner of the land after that point. It's not that this is the only legal power standing in the place of the chopping down of the tree. It's just that if the TPO remains in place, it is a specific offence to chop it down in breach of a TPO.
Is that clear, Councillor?
Just one final thing, and we can say without shadow of doubt, this tree does not belong to this applicant. Yes?
Yeah, it's
not his tree.
It's it's within a different red line, so it's not within the applicant's site.
Okay. I've got much more to say during debate. Thank you.
Thank you. We look forward to it. Roy.
Chair, it's very confusing, but the way I see it is that if it was proven that the tree's roots caused the damage...
Sorry, Roy, I just need to stop you there. Is this a question, or do you want to move on to the debate?
No, go on to debate, please.
Right. Well, I just want to check if there are a couple more questions, and then I'll come back to you. I'll put you first. Kathy, I believe you have a question.
There's a couple, just little. Well, the first one isn't a little question. The evidence that the speaker referred to, and I've got here as well from the other cultural report, was that in the boreholes, the first borehole found no foundations, which is questionable in itself. The ones that did go down, there were no roots found, or the ones that were small and they were dead. So how have you moved, as officers, how have you moved from that evidence to saying that the tree is responsible for the tree, which is 22 metres away, is responsible for the subsidence?
Yeah, so in terms of the planning report, that was put together with the advice from the landscape and ecology officer. So he read through all the reports, and you can see his views in the report that the tree is a good tree, it's a good quality tree, and it's important to Horndon. But also his advice to us as officers was that the information isn't there to show that it isn't causing a problem. So we can't counter that information, and we can't say that it's not responsible for the subsidence. So on the balance of probabilities, as the legal officer has said, we have to fall on the balance of probabilities test that it is causing that subsidence. So that was how we got to the recommendation.
Okay, I just can't see how, if there's no roots there, how it's caused. Anyway, and also a little, just to follow up from what Aaron was saying, just this is a legal question. So if so if we did happen to remove this TPO, but then if the owner of Grice's, who owns the tree, who, as far as I gather, doesn't want the tree gone, if he refused to cut it down, would they not sue him for the damage rather than the council?
I mean, it's hard to advise with certainty what would occur, but the implication of approving the revocation of the TPO is that there isn't then a route to claim compensation from the council, because the test set out in the regulations is no longer satisfied. What would be the case, which I think is what your question is going to, it's then a private law dispute between the owner of the tree and the person who wants it down.
Thank you both. Steve, you have a question?
Yeah. I see we turned down the approval in 2013, and apologise if that's what Kathy asked, but aren't we still liable then for any underpinning or work because we turned it down in 2013?
Not anymore. There's a 12-month period for bringing a claim.
Very good question, Councillor. Thank you. Any other questions? Okay, Tom. Alan, did you? No. So, Tom.
Yeah, just quickly, I'm not sure how old the tree is. I'm not sure how relevant that is. I mean, for me, I think I could really do with a tree expert in here to sort of tell us what the likelihood is of that tree. I know we've obviously got expert officers who have given their opinion. The other thing is, if you buy a home and there's a TPO or there's an oak tree within a certain distance of your property, my understanding was that obviously the home insurance would want to know that. And I just wondered, the whole purpose of a TPO is to protect a tree. So if you're a homeowner and you get home insurance, the insurance would cover potential costs to protect the house from the rooting if it was a problem. I didn't know whether that was relevant. Obviously, it's not really relevant, but I just thought the purpose of the TPO was to protect the tree, and then home insurance would get involved. And so for this to land on our doorstep, is it too soon? Thank you.
Jonathan, do you want to come back on that one?
Yeah, the purposes of TPOs are to protect trees that have a high amenity value. So that's why the council would have put the TPO on at the time. The insurance issue, the insurance potentially would pay out for works, but the point is, in terms of law, as the legal advisor has said, if it's been proven that the council refused the tree to come down and the tree has caused the subsidence issue, then the liability would pass to the council because it didn't allow the tree to be removed. So I understand your point about why the insurance wouldn't pay, but potentially it would pay, but the costs would fall to the council for not allowing that tree to come down.
But just to check, Jonathan, in that situation, if I understand rightly what's been said, the onus would be on the applicant to prove that the tree was the cause.
And that's what the application before us tonight is for. That's the applicant saying, this is what the problem is, yeah.
And that's what they're saying. I'm just sort of checking because we seem to be saying the onus here is slightly less in that we're saying that we just don't have enough information to say it's not, which is nothing like the same as saying he has proved that it is. Chris.
In both cases, the question is whether or not the evidence demonstrates on the balance of probabilities, so 51%, that the tree is the cause of the subsidence. Here, it's that the only evidence provided or rather the evidence that the local authority agree with, is that it does meet that test on the balance of probabilities. Were it to be a civil claim and it was defended by the local authority, i.e. a claim for compensation was brought, it would be open to the local authority to instruct experts to come that would or might come to a different view.
Thanks both. Srikanth and Steve, and then I think we'll move on to the debate.
Thank you, Chair. I have one question. As per the speaker statement, we can see that tree having like historical record and over 100 years. That is, we can understand that 100 years, from 100 years, tree is still there. No issues has been raised. And so from the council point of view, to protect TPO, don't we have a infrastructure like we have like a 21st century, like technology and science very advanced. Based on that, can't we check that one, what is the lifespan, expected lifespan? Based on that one, think and take decision I would prefer. Just I have a question that from the council side, do we have any infrastructure to check whether the tree is going to be, how long can stay, like because having the historical 100 years. Thank you.
I haven't measured exactly how old the tree is, but I know that's sort of important in terms of the residents and the neighbours and the village, but the age of the tree isn't really the question that we have to consider tonight. Is that tree having an impact on the neighbouring property, which is to the root of the issue, unfortunately. So we can't consider how old the tree is, it's just the value it has and the impact it has.
And I commend you on sneaking in the root of the issue comment. That was a really good.
Thanks, Chair. Chris, given your background and knowledge, it just strikes me that everybody's kind of looking at the tree. But if there's an issue with a building, why would you not underpin it first anyway? Because if you've underpinned it, one would assume that you've dealt with the problem, because any roots that were there when you underpinned it would be cut away anyway. Would that not make more sense?
I mean, so my knowledge can extend to advising on the regulations and the TCPA. Oh, sorry.
So you were looking at me, but say Chris, so I was kind of... yeah, obviously underpinning is one option, but what we have before us tonight is the claim that the tree is causing that damage to the property. So we have to consider it on the basis of what's in front of us, but I understand your point.
Thanks, Chris. I give up.
Don't worry about it, Dave. Okay, so I'd like to move on to the debate because I think we will have a few. So I did say that Roy would be our first speaker. Aaron and Jackie, did you have your hand up? Okay.
Yeah, thank you, Chair. Apologies for that. See, that's my point. That's what I was alluding to. It's the claim that the tree is doing damage to the foundations of this building. Now, we know that this building's an old building, and it's been stated that the foundations aren't what they are nowadays, very shallow foundations. But it's not proven that the roots are doing damage to this building, and that's the thing. So when we keep going back to, like, council's liable for this, if something isn't proven, how can you be liable? Or even so, we say no. How can you be, because it's not proven? And that's the main fact of the matter. Thank you.
Thank you, Roy. I think, Aaron, you're next.
Thank you, Chair. This evening, we've obviously heard this report. At the moment, I'm inclined to vote against officers' advice because I do not feel we are in the right place in regards to ownership of the tree. I feel removing the ownership of a tree on an application for an applicant who actually don't own the tree is not right. I feel that removing it with a lack of evidence of foundations is not right. And we've heard many more arguments for that. So at the moment, Chair, I'm under the opinion we should vote against this.
Just to make the point, Aaron, which I feel duty bound to, planning applications, including applications like this, can be made in respect of land you don't own. So whether we like it or not, this is a legitimate form of application.
And I understand that, Chair, but that would be one of the reasons why I would want to vote against this. But I understand that that wouldn't be held up, so I would state as well the lack of evidence regarding the actual subsidence being caused would be my main reason.
Thank you. That's useful to clarify. Thanks. Jackie, I think you're up next.
Yes, thanks, Chair. Yeah, what concerns me the most is this, respectfully to members and officers, we seem to be a committee paralysed by fear of the financial implications. While moral and ethical reasons are not a technical planning reason, can anybody in this room say that if this tree was voted to come down, they would sit at the foot of it and watch it come down and think that was a good day for public service? Because it's morally and ethically, it is appalling. In the report, in one of the statements, it said that if the felling of the tree means that there is no sign of improvement, then they will look at other alternatives. It's a bit late for the tree then, isn't it? It's gone. So that to me implies that there is no evidence at all that this tree is causing this. None whatsoever. We're being asked to lift a TPO, lift a legal protection, really, with no evidence whatsoever to do so. Morally and ethically, and there are obviously technical planning reasons as well, but for me, I agree with Mr. Woodard, it's vanishingly small, that felling this tree is going to prevent this house falling down. The sheer fact that the house is still standing when we were told it was imminent collapse and nothing further, we don't know how much it's worsened since then. We've done no groundwork to see if it's worsened since then. If it was on the verge of collapse, why are the occupants still rattling around in the property? It's not come down around their ears. It's still up. This tree should remain, and I have to take the emotion out of this. We cannot fell this tree. We have to do our service tonight, folks. We really do.
Thank you, Jackie. Kathy?
Yeah, it's hard to follow, but I'd like to follow. Two things really. First of all, I think I know you're saying we don't particularly use the same measure that the speaker used, but I think any sensible person really would regard the amenity value of that tree as greater than the cost of the underpinning. And if it was my tree in my garden, I would pay the £45,000 or whatever to underpin the house rather than cut the tree. I'd also like to say we did some training on risk management and things like that. And one of the risks we have to take into account at all decisions that we make as a council is the risk to the council's reputation. And I think if we were seen as cutting down what is being described as one of the finest examples in the borough of a tree of this kind, and we cut it down on flimsiest of evidence, I think that would do really a lot of damage to our reputation. So I obviously will vote against as well. Thank you.
Thank you, Kathy. Steve, Lydiard, I think you wanted to come in.
Thanks, Chair. Yeah, when you take out a tree, you don't just chop out a piece of wood. You chop out a whole set of wildlife as well. So it's really important that we, love these trees. Really, they are fantastic. On the other sort of side, there was people talking about the roots of the tree causing problem. I think what it might be is that the tree sucks up so much moisture out of the ground, and in a clay, where the ground is clay, it actually reduces the subsoil, and that could possibly be one of the problems of having that sort of tree fairly close.
Thanks, Steve. Yeah, sure. Steve, then Ashley, and I'd like to come in after that.
Thanks, Chair. I probably missed the opportunity when Mr. Woodard was speaking, but my understanding, knowing that area reasonably well, that the house where the tree sits in the garden is significantly older. The tree the house that's suffering harm, and I'm guessing a bit, but it's probably a 1970s kind of house. And going back to what I said before, why not underpin it first, rather than, because then you can do things in a logical step. So if that doesn't work, all right, you're back to square one, which is, well, is it the tree? But if the house adjacent or very nearby was resolved the same way by underpinning it, then I think there's some evidence to suggest that that should work. And I'd also suggest that the tree that we're talking about is much closer to the house, in the garden of the house. It's much closer to the building than than the house it's affecting. So I just don't see any logic in doing it that way round. The obvious thing to do is deal with the underpinning, and that I see no reason in this day and age why that wouldn't resolve the issue. And I agree with Steve's point that the sort of ground heave and so on, I accept that, but it doesn't seem to have done that to the house that it's right adjacent to. So that's kind of my take on where we are with it. Thanks, Chair.
Thanks, Steve. Ash, would you like to respond to some of those points?
Yeah, thank you, Chair. So I think the first point to make really is, officers don't have any pleasure in bringing these applications to committee, but that is the job. The application's been submitted, and the job of committee is to determine the application, and committee must do that based on material planning considerations. So that was what I'd encourage members to reflect upon when they're coming to their decision, notwithstanding, I appreciate this is a very emotive subject. The risk of liability, lack of evidence for subsidence, I think we've covered that in detail, so we talked about the balance of probability. So you have the information in front of you with respect to that. So in my opinion, that's not a reasonable ground to refuse the application upon. The ownership, absolutely not. Committee must determine applications that are submitted. So ownership is not reasonable. The amenity value, however, is a material planning consideration. And Councillor Sisterton has articulated the thoughts on amenity value, and members may wish to sort of consider that further as part of their debate, or they may have sufficient information on that. Thank you, Chair.
Thanks, Ash. I'd just like to sort of just query one of those points there. We have a combination of factors from what we've heard regarding the house at Saffron Gardens. Potentially the tree, definitely the clay soil, and we also have the question of whether in fact the foundations are sufficient, or even in all cases there. There was this reference to the foundations, to there being a lack of foundation in certain parts, unless I've misheard that. So I actually would say that in terms of a reason to refuse this, I would say that one reason for me to, well, let's rein it back a bit. What do I think? So let me be clear. I mean, the amenity value of this tree is very clear. You just have to look at the number of people in this room tonight and the passion with which they followed this debate. Clearly, this is a very, very important issue for this area. I'll be honest with you. If there were compelling evidence that this tree is causing somebody's home to founder, then I would have absolutely no problem in voting to revoke the TPO, personally. My problem is I really haven't heard anything that I would suggest comes anywhere near compelling evidence. We have, if it is the tree, possibly it is the tree, we think it might be the tree. There's no smoking root here so far, if you'll pardon the pun. I do not feel, in both this meeting and the previous meeting where it's discussed, that I've heard anything like the clear, incontrovertible evidence that says the problem underlying this admittedly horrendous problem that the owner of the house in Saffron has got is a tree sitting 22 metres away. I haven't heard that evidence. I don't believe the evidence is compelling. I certainly agree with Ash on purely on the grounds of amenity value alone. I would be extremely loath to revoke the TPO on less than really strong evidence, and we don't have really strong evidence. So I will certainly be voting against. Anybody else? Okay, so shall I go to the recommendation? So the recommendation is to grant consent to revoke the TPO based on the following conditions: notification of works, council tree officer to be informed at least 1 calendar week in advance, and a replacement tree to be planted in the first planting season following the removal, the size, the species and positioning to be agreed in writing. And then we can all agree to come back here in 15 years' time and see if we want to dig that up. Pardon me, that was really not as unbiased as it ought to have been. So, the recommendation is clear. You have the recommendation. Do I have a proposer? It would look really weird if you didn't. No. I only want a proposer for this if somebody actually feels this is something they want to propose. So, Ash, in the absence of a proposer.
Yeah, so it's as per the previous item where we would need a member to come forward with an alternative recommendation with clearly defined reasons. If you wish, Chair, I can sort of articulate what I've heard, if that's helpful. Yeah. So reflecting on the points you've made, Chair, effectively, from what I've heard from the amenity value, the committee have articulated that outweighs any potential costs that the council may incur as a result of refusing the application, and it would effectively cause substantial harm and character to the character of the conservation area, and that justifies its retention. And then I think, Chair, you also made the point that the evidence of probability does not stack up, in your opinion, to support the felling of the tree. They were the sort of personal points I heard from yourself, Chair.
Thanks, Ash. Yeah, I'd agree with those. So, that's fine. That's what we're here for, Aaron. If you can try and keep it brief, what would your proposal be?
Very similar, but I would take out the bit that the council would incur, mainly because we do not want to be going down the line that we think we can incur this. I do not believe we would be liable to incur anything.
Thank you. I think it's a good point. So may I suggest that a proposal as follows, that we propose to refuse the revocation of the TPO on the grounds of A, the amenity value of the tree outweighing the risk of potential exposure to liability, and secondly, on the grounds that, in our view, the balance of probability hasn't been achieved in terms of whether the tree is the cause of the problem. On those two grounds. So I will propose that. Do I have a seconder? Jackie. All those in favour? So the counter-proposal to refuse revocation of the TPO has been carried. Do members wish to take a quick natural break before we move on to the next item? I thought you might. You get a break this time? No? I'm sorry. Yes. Orsett Heath. I'm wishing our time away. My apologies. Does that mean you're still on it, John? Oh, right. And today, and for this item, you're Alan Ward. Yes. I know. I think I left my brain in the gents. Right. Thank you very much. It is item 9. It is Orsett Heath, and it is once again Jonathan Keane. Thank you very much.
Thank you, Chair. So the application site's on the screen in front of you. So it's a rectangular site which encompasses the car park and the application site where I've got the cursor at the moment, which is the existing building. That's an aerial photo which shows the existing building on the site at present. And this is a proposed site plan, so the building is to remain with the same footprint and same form as currently. And there's some proposed elevations for what the building will look like if permission is given for the works. And these are the pictures of the existing building at present. So it's a temporary structure which was given permission in 2022 for 2 years while the Orsett Heath Academy was being built. So the application before you tonight seeks full planning permission for the permanent use of this building for childcare facilities comprising wraparound daycare for morning and afternoons and nursery places during the day. The use will also comprise SEND provision for the Orsett Heath Academy and external areas for outdoor teaching and learning. So the application site is within the green belt, but given the recent changes to the MPPF in December 2024, the council or officers are of the view that the site represents grey belt and therefore the development is acceptable in principle in this location. As you can see from the pictures in front of you, the dwelling would be reclad if permission is granted to improve the appearance of the building for its future use. The application site is close to the rugby pitches and is suitably distant from nearby residential properties for the impact of the building and the use not to impact on neighbouring occupiers. And there is suitable parking provision, and there is also a condition requiring a car park management plan and a travel plan to ensure that parking is suitably managed across the site. So there's no objection raised on parking and highways grounds. So the application would provide much needed provision in the area for childcare, as I said, for day-to-day wraparound childcare in the mornings and the evenings, and also for nursery provision. So the application is recommended for approval and would provide a useful facility in this area for local residents and the community.
Thank you, John. Just looking, I know we have an application, a statement of support. We don't have a. Yeah, we have a statement of support from Steve Monday. If you'd like to come down, Steve, and plant yourself there.
Good evening, councillors, and thank you for allowing me the opportunity to speak in support of this application. For those that don't know me, my name is Steve Monday. I'm the Chief Executive Officer of the South West Essex Community Education Trust, which is a bit of a mouthful on a Wednesday evening, but the Trust is responsible for oversight of Dean Home Primary School, Chadwell St Mary Primary School and Stifford Clays in Thurrock, along with William Edwards and Orsett Heath Academy Secondary Schools. I've had the pleasure of working in Thurrock for 25 years across a range of school settings and phases, and remain as passionate now as I was when I started about improving the life chances of young people that we serve, and this application is certainly to that same end. What I think is very clear to everyone working in education and beyond is that the early years is a crucial stage of every child's development. I want to speak directly to the significant impact of this application if you are minded to approve it. We've applied to repurpose a building erected to provide additional school places at the interim site of Orsett Heath Academy at the Thurrock Rugby Club, an innovative provision that benefited more than 300 pupils at the start of their secondary education. We would like to significantly extend the benefit of that building in a site setting with space, security and safeguarding arrangements ideal for provision of this kind. The intention is to provide urgently needed nursery spaces and wraparound care to support working families in Thurrock. The borough, like many authorities, is struggling to find these much needed places, and as indicated, Thurrock's education department fully support the application and the urgent need that it addresses. Government funding changes in September 24 have further compounded the need for those additional spaces in Thurrock. The provider we are working with has a strong track record of delivering such provision, including for children with special educational needs, and has the infrastructure in place to provide much needed places quickly, yielding an immediate impact if approved. In addition to the profound impact this will have for the children and families directly affected, there are also wider benefits to the community by locating this provision in partnership with Thurrock Rugby Club and Orsett Heath Academy. We strongly feel that the significant and ongoing positive impact that this application will have on so many families and the community more widely makes an exceptionally strong case for the repurposing of the building as described. And given that I have a few moments, I would be remiss of me not to make some comment about young acorns being planted and them becoming great oak trees. And I think, in all seriousness, following the last application, I hope that you see this as a really, really positive opportunity to repurpose a building for years to come. The one thing I haven't mentioned, which I think is important, is that whilst the building was put up as a temporary building, it has an expected lifespan in excess of 50 years. So whilst it was a temporary building when put up, we very much see it as something that will be there for the long term. Thank you very much.
Thank you, Steve. Before we let Steve go, any questions of a factual nature? Nope. Okay. Thank you, Steve. You may go back to your place. Thank you. Okay, so members of the committee, do you have any questions for Jonathan on the application? Shrikant.
Thank you, Chair, for the opportunity. As per the application, we can see that there are currently 178 parking spaces are available. Through this application, we didn't find any EVP proposal for this one. So now this application is having creating lot of facilities and also providing 9 full-time employment and 12 part-time. That is really absolutely fantastic thing I want to appreciate about that one. So, and also there are immediately 30 nursery and 40 secondary, 4 to 12 children's going to be.
Sorry, Shrikant, if I can just pick up, that's actually really useful material for the debate, but if we can just keep to the, if you've got
so
any questions.
So altogether, nearly nearly 200 car parking spaces going to be required based on this data. If I'm wrong, please correct me that one. There is no proposal for the EVP. So as per the current requirement policy, there is a EVP required. So just I want to raise the question, did we ask the question about to put a proposal for the EVP for the future through this application? Just I'm having a query. Thank you.
Thanks, Shrikant.
Julian.
Julian.
Just happy to answer that question.
Yeah, thank you, Chair. In terms of the parking, there's well in excess of the parking that's required for the nursery. The parking as a whole accommodates the rugby club, so it's there, but the times of operation of the nursery won't interact significantly with the rugby club. And looking at the parking during the times that the nursery would operate, that there's not a lot of parking in the car park. As part of any requirement within car parking standards, EV parking requirement is required with any new development. So EV would be included with this development as well.
Thanks, Julian. Any other questions? I've got a couple, if I may. Julian, the parking, are we looking at, so in terms of saying yes, there's sufficient parking, are we looking at relying on the main club car park, or just the car park for the what was the temporary school building?
Yeah, well, the facility is all there within itself, so the opportunity is that they're in excess of the number of spaces overall altogether. And as I said, there's no interaction between the rugby club and the operation of the nursery anyway. So in terms of the parking, we've just put the car park management plan and the travel plan as we would do with any new school facility, because we feel that it needs to be managed appropriately, and if there is a need to rearrange the parking or change the parking in any way, then that would be accommodated within the car park management plan. So it's a add-on that we would add to any school, no matter whether there was enough parking or there was, you know, just sufficient parking. We need to ensure that in the future that there's the appropriate level of parking for the operation of the facility.
That makes sense. Now, on a similar note, what this will likely do, I would guess, particularly with the wraparound, is divert some of the traffic that would normally go into Stamford Road, where you're dropping your kid off, onto Long Lane and the club approach road, because you're dropping your kid off at the wraparound site. Have we looked at the likely increase in traffic along the end of Long Lane and that approach road as a result of this?
Thank you, Chair. We have, and in terms of the level of traffic, obviously, like any facility of this nature, it operates slightly different to what a school would be. So it's not like 8 something in the morning until it obviously has afternoon and morning sessions and whatever it is. There's obviously a mixture. And in terms of that, where we've looked at the traffic impact, and it is no severe issue of the traffic impact. As you recall, that there was already a level of traffic associated with the development previously. So this is no worse. In fact, it's probably not as worse as what was there previously.
Thanks, Julian. And one last question for yourself, Jonathan. I think this is mainly because it's a relatively new element of law. When you mentioned this is seen as grey belt, I think it might be worth just briefly explaining why the team regard this as grey rather than green belt.
Okay, so the sort of main section of the report on grey belt is pages 58 and 59. So one of the tests for grey belt, or the main tests for grey belt, are they're looking at the original purposes of the green belt, and they're tests A, B, and C. Sorry, no, wrong section. Sorry, on page 57, three of the purposes of the green belt are to check the unrestricted sprawl of large built-up areas, prevent neighbouring towns merging into another, and preserve the setting and character of historic towns. And the test for grey belt is whether those purposes of the green belt are harmed by the proposal. And in this case, the proposal wouldn't result in a sprawl of larger built-up area. It wouldn't result in neighbouring towns merging together, and it would preserve the character and setting of historic towns, because there are no historic towns nearby. There are other sort of specific details and conditions, but the main thrust of it is grey belt is if it complies with those 3 tests, and it does in this case. So given it is a very small site and there aren't wider harms, it's considered to be grey belt, and following from that, it's therefore acceptable in principle.
Thank you. Appreciate that. Okay, so if there are no more questions, perhaps you would like to move into the debate. Steve?
Well, I've just got one last question for Jonathan. So given the way you've just explained the acceptance of that now being grey belt, had we not given temporary planning permission 3 years ago, it wouldn't have been, would it?
It could potentially still have been, because the site is very small, and the the building itself wouldn't, even if there's no building there today, if this building was proposed now, it still wouldn't cause harm to criteria A, B or D set out on page 57. So the wording of the MPPF says it can be previously developed land and or other land, and this would, if there was nothing there, it wouldn't be previously developed land, but it could be other land that could still be considered grey belt. So I do take your point that it may, well, potentially it could be thought to be looked at differently, but I think given the size of the building and its location, I think we would still come to the same conclusion.
Thanks, Jonathan. I just think it may have been a different debate had that temporary permission not been given, but thanks anyway.
Thanks, Steve. So, that it for the questions? So let's debate. Who'd like to start? Roy.
Thank you, Chair. I think there is a lot of pluses for this application. Much needed nursery and school places. It isn't going to upset neighbours. It's been there. It's worked well. It's a proven product, should we say. The buildings are going to be upgraded, reclad. So I think this is a marvellous opportunity to enhance our education in this area. So I think it's a great, good idea. Thank you.
Thanks, Roy. Anybody else? Aaron.
Just seconding what Roy said, this is actually a big plus for Thurrock, with many children who need now SEN provision, and the lack of SEN provision in Thurrock. Having extra spaces that can be used is going to be a huge plus and a huge benefit to our residents. So I'm all for it.
Thank you. Steve?
Yeah, I agree with that. I mean, much needed accommodation for young children. And I used to live in Long Lane, so I can't see any problem with traffic. I know the rugby club pretty well, and the times that they'll be using it was earlier in the day, whereas a rugby club uses it at night. Yeah, so I'll be supporting it 100%.
Thanks, Steve. Anybody else? Other Steve. Again.
Thanks, Chair. Much as I appreciate and don't disagree with all of the positives that have been put forward, obviously you understand my feeling about the Greenbelt, but the other thing that concerns me slightly with it is we're building a nursery right next door to the Docks Approach Road and what will be the Lower Thames Crossing. Just a thought.
Thanks, Steve. Yeah, that is, I mean, appreciate that we can only really look at this on the merits of the application that's being brought in front of us. I think it is fair to say that the field immediately to the north of it is being looked at potentially for as part of the Blackshots estate development. So at the end of the day, you know, there could well be much more than just those demountables going up. I think personally, the one thing that I do, the only caveat for me is that I think it will generate traffic during the weeks that at the moment doesn't exist. But I think the point has been made, and fairly made, that compared with a couple of years ago, for about 3 years when the temporary school was in operation, it will be a good deal less volume of traffic than it was then. So I don't, you know, while I accept that it won't be quite the, I think no impact on residents, there might be some, but it's difficult to argue against the requirement for nursery places and, as you mentioned, Aaron, decent quality provision for children with SEN needs. Okay, so Jackie, you'd like to say something?
Yeah, thanks, Chair. I'm obviously with Steve on this. I mean, to put it out there, I come to these meetings with an open mind, but I am an advocate for protecting Greenbelt. We know that. I make no secret of that. But for my day job, I see an awful lot of frustrated parents who come through my inbox every day because they cannot get a send place. And I, as much as it goes against what I would ordinarily consider to be an assault on the green belt, even though I come here with an open mind, I couldn't not vote for this based on the fact that we are desperate for these places.
Thanks, Jackie. And I mean, just to add to that, I think it is probably a slightly different conversation than it would be if there weren't already buildings there. So, you know, the actual impact at this point is a lot less because it's already, in fact, it'll look a lot better from the look of it. But yeah. Okay. Shall we move on to the recommendation? Okay. Make sure I get the right recommendation. So, recommendation is that the Chief Planning Officer be authorised to grant permission for this development subject to those conditions set out in section 16 of the report. Do I have a proposer? Aaron. Seconder? Roy? All those in favour? All those against? Okay, got to ask the question. Okay, thank you very much. I don't think we have any abstentions because I think we had an equal number of hands and people. So, thank you. So, that recommendation has been passed. Right, before we move on to the next item, which is item 10, see I am paying attention, I would like, I'm looking for the form of words, I would like to move a motion without notice to suspend Council Procedure Rule 11.1 to allow the meeting to continue beyond the 2.5 hour time limit. We are 8:05, we've got a couple more items to go, so any objections to that motion? Yeah, a couple can be 3, between friends. So that motion is passed. Excellent, thank you very much. So we are now on to item 10, the flagship centre, and would the real Alan Ward please present for us?
Thank you, Chair. Sorry, just waiting for the presentation.
If he doesn't come up, how do you feel about doing it through the medium of dance?
I could try, but I wouldn't want anyone else to experience that. While that's coming up, here we go. Thank you, Chair. So the Planning Committee resolved to grant planning permission for the land adjacent to the flagship centre back at the October 2023 Planning Committee for a youth centre with a sports hall, included several facilities, fitness centre, boxing suite, climbing wall, and a mixed-use games area. Here's a CGI of, from one angle, of what it's going to look like. Let's say resolution to grant exists, so this is coming back to Planning Committee tonight because when it went to Planning Committee last time, the recommendation also came with a Section 106 legal agreement to secure highways works under Section 278 agreement and also parking improvements to the area. So the conundrum here is actually it's a council-owned site. So the council can't enter into a legal agreement with itself, and the applicants can't enter into a lease to take on the site without a permission in place. But we cannot issue a permission because we can't get the legal agreement with ourselves, and therefore we are stuck. So this is known as an extraordinary circumstance whereby we need to create a negatively worded condition that requires a legal agreement to be entered into prior to the occupation of the development so that we can actually issue planning permission, and also the off-site highway works will be controlled by planning condition as opposed to Section 106 agreement. but the so it's relatively simple. Basically, we add planning conditions to allow ourselves to issue permission, which allows the applicant to enter into a lease for the site to actually provide the facility of a youth centre. Sounds a bit complicated, but it's really just the addition of planning conditions to gain what we presented to Planning Committee back in October 2023. So recommendation, Chair, is simply to provide those conditions to ensure that we secure the planning gain, essentially, that we referred to back in 2023. So the permission will get issued. We have surety of gaining the highways works, the improvements to parking in the area as well, and all the other planning conditions that were recommended back in 2023. Thank you, Chair.
Thanks, Alan. So in my understanding, it's basically a workaround to ensure we can still deliver the full benefits by getting around the legal niceties of what we can and can't do.
Yes, just technical issues and overcoming them. Thank you.
Does anybody have any questions on that? So we can't, if I understand it right, we can't impose a Section 106 on ourselves, and we can't effectively let the applicant have the land without certain conditions. So this basically allows us to do it in a way that doesn't put us in a weird legal or technical position. But don't take my word from it. You can always ask Alan to repeat himself. So seriously, do you feel you need to ask any questions, or are you comfortable with what you've been told? Or thirdly, are you prepared to trust Alan? No? Okay. So, well, no, Steve, if you've got a question you want to ask, feel free.
Thanks, Chair. I was just going to repeat exactly what you said. 2 minor amendments to for administrative reasons to get where we want to go, but it has to come back here to Planning Committee because as a council we own the land, therefore it has to come back to us to make the decision. So I just want to go straight to debate and recommendation, really, Chair. Thank you.
Thank you, Steve. I think that makes sense. So would anybody feel confident enough to debate it? Does anybody have any concerns around because, okay, what effectively we're saying is we've already discussed the actual application. The application was passed. We know what we want to deliver. We have a technical problem here, and what we're suggesting, we're not going to reopen the original application. There's nothing to do with that. It's literally saying we need a workaround. Can we do it?
That's fine.
Yeah? And I really don't know how to put it any way other than that. But I do want to, so if you feel there should be any concerns raised, now's the time to do it. Otherwise, yeah, we'll go to the recommendation. So, anybody got any concerns about what we're proposing? No, good. Okay, so the recommendation. Approve, subject to planning conditions. Do I have a proposer? Steve. Seconder, Roy. All those in favour? Yeah. Okay. Oh, the thing I didn't mention is there will be a test on this item afterwards. Okay, thank you very much. So that recommendation has been approved. Right. Now we're on to item 11. I'm back where I thought I was, and we're no longer in Kansas. So item 11 is the RG Cole building, and Lucy, I believe you're presenting.
Okay, thank you, Chair. So, yeah, this application is for full planning permission for demolition of existing premises and construction of a new 3-storey block to provide a mixed scheme of 2 retail units and 7 apartments. By way of an update, the description on page 3 of the report refer to a previous iteration of the proposal, and this application is for 7 apartments and not the 9 referred to in the table 3 pages into the report. And also today, the applicant submitted a transport technical note regarding parking in the local area.
Lucy, is it worth summarising that technical note, or do you want it to take it as read?
Well, I can summarise it. Basically said
That'd
that
be helpful, I think.
Looking at this certain parking standard, that there was enough room in the surrounding streets because there's no parking with this application, that there was sufficient capacity for this development. That's pretty much all it said, and I think that I'm sure we'll come on to that later, and Julian can help with the details. Okay, so this is the site location plan. So the site is located to the east of Greystown Centre, within the urban area and on a principal route from Tilbury to Grays. The most recent use of the site was as a kitchen and bathroom showroom, set in a mixed single and 2-storey building. The building forms part of a local neighbourhood centre along Broadway. Okay, so this is an aerial photo of the site. So the site is centrally located here. And then this is a closer aerial view of the site with red line around it. Okay, so these are the existing plans of the building at the site. So it's got retail area to the ground floor and offices on the first floor. This is the proposed layout. So as I said before, the proposal is for 2 commercial units and 2-bedroom residential unit alongside bin storage and cycle parking on the ground floor. The first floor would have 3 2-bedroom residential units, and the second floor would have 3 1-bed apartments. There is no parking or private amenity space provided. The MPPF requires that the starting point for consideration of this case is a presumption in favour of development unless other matters significantly outweigh the benefits of the scheme. Set against these benefits is the lack of car parking provision. This lack could lead to an undue pressure on on-street parking in the area. The weight given to this is limited to a degree by the readily available modes of transport and the site's location close to the town centre. The potential harm arising from the development is not sufficient, to outweigh the benefits of the proposal. So this shows the proposed elevations in comparison to the existing elevations. This slide shows the building heights in the immediate surrounding area, with the application site just right of the centre, so just here. So there's a few other 3-storey blocks in the immediate vicinity. Okay, so next on to some photos. So this is the site viewed from the other side of Broadway. This is the site viewed from the north, facing southeast onto East Thurrock Road. And this is the site viewed from the southwest. The proposal represents a sustainable form of development, providing housing and retaining a commercial use on the ground floor. The MPPF requires the starting point as a presumption in favour of development unless other matters outweigh the benefits of the scheme. But as I said before, set against these benefits is the lack of car parking provision, but the potential harm arising from this is not sufficient to outweigh the significant benefits of the proposal. So to conclude, the recommendation is to approve the application for the reasons set out in paragraph 15 of the report. Thank you.
Thank you, Lucy. Before I ask you to direct your questions to Lucy, we have two statements of objection. One of them is from a local resident, Grant Morris. Grant isn't here, so I'm going to work on the basis that you've read his statement. Is that a reasonable assumption on my part? Fantastic. And in that case, I will move on to our second statement of objection from Ward Councillor Rob Gledhill, and Rob is here. Thanks, Rob. You'll have 3 minutes, and you know how to work the thing.
I should do one now. I'd like to object to the application based on the following. As anyone who travels along these roads leading to the proposed site knows, it can regularly and very quickly be congested, not only from the sheer weight of traffic, but due to the vehicles parked on the 4 adjacent roads. This is not just an occasional something that happens, it happens many, many times a day and is compounded by the school run. But a vast majority of the congestion is just sheer weight of traffic on the road, on roads laid out in Victorian times before the concept of the motor vehicle for personal use was a concept. The Broadway is a popular site for both takeaways and groceries, so it can become gridlocked with just a few cars parked in line with the current traffic restrictions, coupled with the now normal traffic flow. I have reported this on many occasions as the elected member for the area, and the issue only seems to get worse. This is not only on the Broadway, but on East Thurrock Way, where large private commercial vans have little alternative but to park on the pavement to allow the traffic free flow of movement along this busy A road. I feel the extra vehicles this proposal will generate will only compound the issue, making it less safe for residents to walk unimpeded along this stretch of road. Picking up on the concerns regarding parking, 7 flats were built next door to this application a few years ago, despite the planning committee being flippantly told that the properties were probably only 849 metres away from Gracetown Centre, so did not require parking conditions. But the condition was put on that occupiers could not own vehicles, and that if parking permits were introduced, they wouldn't be granted. However, the council's already breached this. Yet now we find this site no closer to Grays than its neighbour is over 1 kilometre away from the town centre and therefore should require parking. We cannot allow further breaches of our own planning policies by allowing no parking provision on site. Moving to the bus service that's used to justify no parking provision, that has been slashed to an hourly service for around 12 hours from 6 AM to 6 PM in either direction. Hardly a location best served by buses for those on shift work at the ports, at hospitals, or indeed the logistics centres across Thurrock. Anyone who regularly travels this route will know that the corner site has been supplied high-quality fitted kitchens and the like. There was not a high footfall retailer, not 30 or 40 customers a day. It was hardly ever that busy, and it certainly wasn't busy in those volumes. But despite this, the local parking zone was amended to accommodate those customers who may be there for 30 minutes or so, replacing this with 7 flats and 2 retail units, with the possibility of looking at 10 residential vehicles parking up for 12 to 14 hours a day, plus the delivery vehicles and customers to the new premises in the only set of shops in Essex with no dedicated parking zone is chaos in the making. Moving on to the amenity space, the report refers to local open spaces such as Gracetown Centre and Elm Road's open space, both fine popular sites but hardly convenient when you have to cross very busy roads, now made more difficult by this application. In my opinion, this really doesn't meet the criteria for amenity space, and this is something else you should take in consideration in making your decisions, and apologies for going slightly over.
That's fine, thank you, Rob. Before you go, councillors, any questions of a factual nature for Rob? No? Great. You may return to your seat, sir. Thank you. Okay, so going back to Lucy's report, so it's now the opportunity for you to ask her questions. Aaron?
At the beginning of the report, we talked about a transport delivery report. Can you just confirm where that is, please, or if we've not been provided it?
Oh, you're referring to the update that was received today? Yeah, so that was received today, so you wouldn't have had view of that, but it was simply putting forward the case that they considered through the methodology that they had used, that there was sufficient parking in the area for the proposal.
Chair, on that reason, I'm on the opinion now we should defer this item so we've got time to read that document and also have a site visit. I don't think we've got enough information, and I think that is going to be a very important document to us making a decision this evening. So my opinion, and I'm sorry to bring it up now, Chair, is we defer.
Thanks, Aaron. What do the rest of the councillors think? Do you feel you have enough information to debate this, or would you prefer to go take a look at the site?
I mean, as ward councillor, I mean, I know the area very well, so I probably wouldn't need to do a site visit. But having said that, if it helps the issue of this missing information, actually a site visit may be worth it for members. But again, it really is down to a councillor's opinion whether you think it's worth it. Thank you.
Yeah, sorry, Kathy.
Yeah, I don't know it hugely well, but I know it well enough from visiting RG Coles. Parking is definitely an issue right now. I mean, there's no doubt there's limited parking, and I think the question I'd like to would if the flats were built, would they qualify for the residents' parking in the streets around?
Thank you, Chair. The answer is yes. There have been recent High Court cases where planning applications have tried through Section 106 or other conditions to limit residents to zero parking, so they were not able to obtain parking permits. Recent High Court cases, as I said, have indicated that that is not legally available to any council. So the answer is they would be able to apply for parking permits.
Thanks. My apologies. Obviously, we've gone from do we want to defer to going into questions. No, totally my fault. I'm the chair. I do think, though, that I'm going to suggest, Aaron, we sit for a moment on this suggestion of deferring. Let's get the questions out of the way first, because I can't stress this too much. I only particularly want to defer this if we actually feel we don't have enough information to make a decision tonight.
On that point, if we don't defer, I'm not saying we should do it, and I'm not putting a gun to anyone's head, but I would be inclined to vote against it just on the fact of...
I'd be really keen to hear that, Aaron, but at the debate stage, if that's okay. So let's get the questions out of the way first, and then we'll get back to whether we have a debate. So Roy and then Steve.
Thank you, Chair. If parking permits are granted, Julian, where would they be expected to park? Up Whitehall Lane, or, what would be the designated area for the people from that site?
Thank you, Chair. Well, anywhere within the marked resident parking zones. Now, I'm not 100% sure because I'm not an expert, because I know there are various parking zones in that area. So if you take where I live in Stanford-le-Hope, I'm in A, but I can't park in B and I can't park in C. So I'm not sure what zone they potentially might fall in, or if Whitehall and Grove Road and the other roads are all in the same zone. But whatever is the designated zone that they would be in, they would be able to park within a parking permit area with whatever they're designated. So if it was Whitehall Lane, they would be able to park in Whitehall Lane.
Yeah, sure.
Lucy, amenity space, there isn't none at all, is there? There is no spaces for people to sit in a yard or anything like that with the 7 dwellings?
That's correct, Councillor. There's no amenity space provided within this proposal whatsoever. So the report draws out the nearest public open spaces.
Thanks, Lucy. Steve, I think you were next.
Thanks. Lucy, can you confirm that all of the flats have sufficient space for the occupants? Because it does look extremely tight.
Yeah, thank you, Councillor Lydiard. Yeah, all the flats meet the national nationally described space standards. So they all exceed the national standard, which was, I think, bigger than the local one we had in the past.
Another one, if I may, Chair. I mean, I use that road probably 4 or 5 times a week. It can be an absolute nightmare. If someone's building outside that place for, I don't know,
Steve.
3 to 6 months.
Sorry, Steve, I'm going to say the same as I did to Aaron. Unless that's the question, can we
Well,
come back to it?
Well, that is a question, yeah.
Oh, right.
What
have that
sort
then?
of provision you're going to make for traffic management? Because I just can't see it working that well, to be honest.
Thank you, Chair. Not necessarily consideration that we would make at this stage in terms of a highway impact, but obviously you're right to raise that outside of that. If the application was approved, then yes, I suspect there may need to be traffic management measures in the area, particularly to control construction traffic and offloading and loading of materials and whatever it is, but that's not necessarily a material stage that we would take at this stage in terms of the highway impact. We would be more looking at it in terms of traffic impact, but it's obviously something we would indicate that there would probably need to be a construction management plan and a construction traffic management plan as part of the conditions.
Yeah, sorry to just interject, yet there is a condition proposed for a construction environment management plan.
Thanks, Lucia. Sorry, do you need to clarify that between yourselves or?
I think in this case we would want more than a SEMP. We'd probably want a construction traffic management plan as well, from a highways point of view.
Thanks, Julian. Appreciate it.
Thank you, Chair. So, looking at this particular site, obviously it's outside of the 1 kilometre zone. I appreciate it's only just outside, but about 10 years ago we had a scheme 20 metres up the road that was just inside, and they were given approval because it was just inside. Obviously we have parking standards, it doesn't appear to meet those. It is outside that zone, and I think if we're gonna look at a previous site and say you've just about inside the zone, so we're going to allow you to have no parking spaces, ultimately, really, the rules should suggest if you're outside the zone, you're outside. So it was really just yourself, Julian. Looking at this, it's saying, you know, servicing the retail units would be from the pavement, but these are retail units. Obviously, they're going to have deliveries, construction. It says really they should be providing 9 to 11 spaces. So from a highways perspective, obviously you would have expressed an opinion to the officer. The officer then has to make a judgment. What's highways? I mean, are you satisfied that this is okay? Because normally highways would put in an objection, and I wasn't sure whether you had one here or whether on balance you've just expressed an opinion. Thank you.
Thank you, Chair. At this stage, it is a difficult one. I don't disagree with you. We actually asked for further information. I haven't had a chance to fully read that further information. I've got to be frank and honest. And without an understanding of that, at the moment, yes, we, from a highways point of view, but ultimately though we've raised it, it's not a decision for us to make. We've just obviously highlighted that we required the further information to make a full and complete highway decision on balance.
Thanks, Tom. Any other questions? Okay. So before we go into the debate, I will again put the question around about, do you feel that you have enough information to form an opinion? So at this stage, I'm not going to table a vote on whether we defer. I'll see what we get to when we actually complete the debate and come to the recommendations, if that's okay. Aaron.
Hearing from Julian that he still hasn't had time to read the report, a report we haven't seen as well, and I feel if Julian got time to read that report, we got to do that, we would have more information, especially on the parking situation, on the highways. I feel things could change. And so at this point, I'll remain on the fact of we should defer. And I do think if we're going to defer, it'd be worth having a site visit at the same time.
Thanks, Aaron. Good point. Who else would like to contribute? Pros, cons, considerations. I think actually, Tom, you actually made quite a good point as part of your question. Perhaps you'd want to reiterate it?
Sorry, are we now the debate phase or?
We are now in the debate. We've done the questions, so nobody's asking what, why, when, or anything.
Okay, thank you. Right, so look, it's not ideal. There's no affordable housing, lacks amenity space. I think there are some real concerns with highways. We have these standards. They're not being adhered to. It is outside that kilometre zone. We were very tolerant 10 years ago when we gave approval when it was just inside. This is just outside, so we do need to stick to these rules. Parking and concerns around that is a clear material consideration. You can see in this report that whilst it is up for approval, and I can see it was a very balanced, close decision, that there are concerns here. So for me, I'll be voting against. I would stick to just parking. I think there's a lot there to chip away at. It's not just the lack of spaces. It's where would the delivery vans go? How would you construct on a corner like that? Broadway has historic safety issues. We seem to really struggle to be able to fix that parcel of highways. It's just, I think it's the huge amount of built up form in that area. Very, very difficult to sort of drive past that of an evening. There's cars parked up on the verges, even on the double yellow line. So for me, it's a pretty conclusive refusal. I'll focus on the one issue, which is parking, and there's going to be a lot to take away there. It's not just the lack of spaces. Thank you.
Thank you, Tom. Anybody else? Roy.
Sorry. Thank you, Chair. I think it sums it up really on page 96 of the agenda. It simply says, this is a busy and dangerous corner for pedestrians. It is a vital crossing for school children, the elderly and the disabled. The corner urgently needs upgrading with widening roundabout and traffic lights. I think that sums it up. It's too much in such a short space. They're trying to cram too much in it, and we're creating more problems. It's bad round there for parking as it is, and we're just creating more problems for ourselves. It's just, I think what Tom said, it's just too much. Thank you. Thanks,
Roy. Kathy?
Thank you, Chair. Very similar to what Roy just said, actually. To me, it seems, I know it's the largest site, but they're trying to cram too much in, and it could be done in a way, so maybe I agree, shops are good to have, and maybe 2 or 3 flats, but to try and get 7 flats and to lose all the amenity space, all possibility of sort of on-site parking, I feel it's too much for the area that is in.
Thanks, Kathy. Srikanth.
Yeah, parking is a big issue in Thurrock district, especially where I live from the Evelenda plant. Lots of residents having concerns about the parking spaces. So I can feel the pain of the residents, because without creating parking spaces, creating more properties and bringing which is more congestion and we are creating problem with our own decisions. We need to make sure, without creating parking spaces, we should not consider any application for the new build properties. That is my opinion. Thank you.
Thank you, Shrikant. Anybody else? Okay, if I might just add a couple of points. I mean, I think the points seem pretty clear. We are talking about concerns around parking. We are talking about concerns around this being a very busy corner. We're talking about lack of amenity space. I mean, as I've noted here, no parking, but no amenity space, but outside the 1 kilometre, but traffic situation known to be an issue, but personally, this does feel to me like we are trying to be as elastic as we possibly can with our own regulations, and on at least one of these, the band is going to snap. It does feel to me like it's probably one of the least convincing applications I've seen in terms of really not meeting any of the basics that one would expect in a residential application. And it feels like we're almost bending over backwards to make it fit. I think on any one of these, I would probably have an issue. The lack of parking, a point was made to me that, well, okay, so people with a car wouldn't buy it. Not sure. Lack of amenity space, as we've already said, the amenity spaces that have been put into the report as alternatives are not really practical alternatives. Convenient for the town centre, it's not, it's over 1 kilometre, and the buses are only 1 an hour. None of these offsetting factors really seems to stack up. So I have to admit, I agree with the rest of you who've spoken, which is, I really can't see how this is how this, as it stands, is a feasible, attractive, and realistic or realistic application. So is it worth us going to the recommendation? Right. So the recommendation is that the Chief Planning Officer be authorised to grant permission for the development subject to conditions. Do I have a proposer? No. And in the absence of a proposer, we can't carry that proposal. Ash, any thoughts on where we go from here? I just find it handy to get your opinion.
Yeah, no problem. So we'd have to get another alternative motion. So from the debate, from what I've heard, I'm not convinced that there's a reasonable grounds for refusal. From what I heard, it's effectively over-intensification, parking and lack of amenity. They were the sort of 3 areas that I kind of heard, which obviously someone may wish to put forward. What I would say at this point, if members are minded on that front, I'd be suggesting it would be similar to previous cases where it's minded to refuse but is deferred, so we can come back with a report to address those points on the basis of sort of my concerns around the ability to defend those reasons.
I'll take Tom and then Aaron.
Okay, thank you. So I'd like to recommend an alternative motion, which is one of refusal. Looking at the material consideration, a clear material consideration would be insufficient parking, traffic and pressures, and in addition to that, access and safety issues. Just picking up on that, we've recently just approved our parking standard. So it's an updated document. This does not meet that recent updated document. And in addition to that, it is outside of the 1 kilometre zone that has been approved. I would also highlight that whilst it's only just outside, we have record of approving schemes inside that zone, just on the border. So we have to stick to the rules of outside the border. I personally think that is clear and material. I personally think that's enough. But listening to officers' experience, if they want to take it away and bring it back, I will support that. But I personally think we could potentially rubber stamp it, but I don't want to argue with the officer's opinion on that. So that would be my motion. Thank you.
Thanks, Tom. Before I go on to Aaron, I just noticed, Julian, did you want to come in on that?
Yeah, thank you, Chair. Refusing just on parking, it would be potentially quite difficult. Members would have to consider whether there was a PMD9 issue, and that no parking would then cause road safety issues, in the fact that the parking might potentially migrate into inappropriate places within the location. So
yeah, thank you, Chair.
PMD8 and PMD9 really need to go together.
I was thinking more reference Tom's point about the parking standard. Is that correct?
The parking standards were up in February 2022, were the latest parking standards. They are still very similar to the old ones, where obviously within a certain distance of the town centre you are in a medium accessibility, or outside you're within a low accessibility, so that is 1 kilometre.
Yeah, thank you,
So he's
Chair.
correct then?
Yeah, they were updated in 2022, yeah.
Right. Sorry, Tom, back to you.
Yeah, I mean, you could potentially, if you're worried about safety, potentially we could potentially drop that one, even though I think it is incredibly valid. I would say, look, we agree these documents. We have the borders. You know, this is outside of it. If we're going to say, oh, actually, the 1 kilometre rule doesn't actually matter, well, then get rid of it. If we're saying parking standards are not valid, then get rid of them. But our parking standards are already incredibly poor. You know, we're not asking a lot here. So, look, I'm sticking with it. I do think on appeal, this is gonna have some, you know, a bit of strength. I feel that confident about it. I'm slightly sceptical about it. There's no point in taking it away. Parking is a material consideration for refusal. We've got documents that back up our concerns based on what we've approved recently. But having said that, I do respect the officer's opinion. If they generally feel it's worth taking away and coming back, they're more than welcome to. And I would support that. So
okay,
my motion was refuse on the grounds of lack of parking. I'm happy to drop safety if that's mixing things up again, but it might be my colleagues want to add that. Okay, thank you.
Thanks, Tom. We'll take these next two inputs, and then we'll come back to your proposal. Aaron, and then Roy.
Thank you, Chair. I would like to put
Sorry, Jackie, if I missed you. Like I said, Aaron, and then Roy.
Thank you, Chair. I would like to put an alternative recommendation then from Councillor Kelly. I'd like to put a recommendation that we defer the item pending looking at the transport document. Julian gets time to look at it, and officers get to look over our concerns. We may all come to the same idea again. Also, I think we should have a site visit, because there's some of us who I know this site, but I know there's a couple of us who may not know it as well.
Thanks, Aaron. Roy?
With respect to Aaron, and I can fully understand that he wishes to take a look. I know this site very, very well, just like as Tom said. And to me, I feel it's overdevelopment in a dangerous area, that corner. That is one of the things I would add to what Tom said. That's the way I see it. I think the construction would cause issues and would be dangerous. You're going to have 40-foot lorries pulling up there to unload materials. You have cranes there to be putting steel up and such like. It's too dangerous. So I would say it's overdevelopment in a dangerous area. Thank you.
Thanks, Roy. So we have potentially two different proposals. We have the proposal to refuse based on parking and safety. We have the proposal to defer, I guess minded to refuse, but defer in order to properly review the transport document and see whether that gives any more clarity around the transport situation. Ash, do I take one and see if it falls and then take the other? And which one do we go for first?
So the first one, so Councillor Kelly has obviously suggested a motion. And just to go back on a point there, Councillor, that those are material considerations. That the point was, I think as officers, we need the opportunity to come back with additional detail on those. But yeah, that's the first motion that's come forward, Chair, so you may wish to vote upon that, and perhaps if, I just want to be clear, members can recall Councillor Kelly's suggestions, or we can repeat them.
Yeah.
Let's put the proposal to members, and that gives Councillor Kelly the opportunity to repeat.
Yeah, so I'd like to put forward a motion to refuse the application, and that would be to insufficient parking and parking pressures, which I consider to be two separate things. So you have the fact that there is no parking, and then you have the added that you're then adding more parking pressures to an area that's already got huge issues and parking enforcement. I'll leave it at that for the moment.
So that is the proposal. Obviously, Tom is proposing it. Do we have a seconder? Alan. Got there first, sorry, Roy. All those in favour of Tom's proposal to refuse? Okay. All those against? And do we have any abstainers? Right. I have casting vote on that one, so I will stick with my vote against and ask us to move therefore on to Aaron's proposal to defer. Now, don't let me put words into your mouth, but defer minded to refuse, but pending A, the review of the transport document, and B, the opportunity to view the site. Yes?
And also any other material items been brought up by the committee today, concerns.
Sorry, and can we add with the chance for officers as well to come back with responses to issues we brought up?
So the proposal is to defer minded to refuse in order to A, review the transport document, B, allow officers to address the concerns brought by councillors tonight, and C, God, I've forgotten C. Oh. C, site visit, just to make sure that we are as clear as we can be on the risks. Yeah, we haven't had that tonight, so go for it. Unfortunately, this means I'm going to have to remember what I just said and repeat it to you. Two seconds, folks. I think we have a...
Yeah, so can I just clarify, Councillor Green, your motion? You're minded to refuse on the basis that you don't have enough information, is that? Or is it you just wish to defer because you don't have enough information?
I wish to defer on the reasoning of we do not have, the transport document has not been reviewed by Julian, and also I would like more information on some of the material items brought up today.
Okay, that's fine. So, Chair, so on that basis then, so if members vote in line with that motion, officers will come back with a more detailed report based on the points raised during this meeting. But yeah, just to be clear, it's defer on the basis of further information to be provided, and also publication and review of the report by the transport team. Yeah, that's fine. I'm happy with that.
Thanks, Ash. If I can, and I want to mention it now, not to... Sorry, Jonathan, if I can just make one point. I think I particularly want to raise it now so that it's not sort of lost. I think one of the things we do need to review as a result, one of the opportunity of deferral is for officers to review the concerns we raised. One of the specific things I would like to see reviewed and addressed is the point that's been made that this prima facie seems to fail to meet a number of our base standards. And I want to hear why we should be minded not to stand on that, because on the face of it, exactly as Tom said, if we're going to have standards, we need to make them. So I think that is one specific point I'd like to see addressed. Sorry, Jonathan.
You've just answered the question I was going to ask. So yeah, so which bits you wanted us to cover, but that's fine.
You know what, I'm terribly previous. Right, so the proposal is to defer in order to A, review the transport document, B, to allow officers to address those material issues that we have raised. Yes?
Didn't you want to chuck in the site visit?
And the site visit will be, yes, we'll tack that on. So I assume that Aaron is the proposer. Do we have a seconder? Steve. All those in favour? Yeah. Thank you very much. So the motion to defer is passed. Thank you very much for your input on that. I think we've given that the attention it deserves. And I've now lost my script. So our final item, item 12, which is Bombers Cafe. Lucy, can I ask you to present on that one, please?
Thank you, Chair. So this application is for full planning permission for retention of a cafe building. Oh, cool.
Sorry about that, Lucy. Just involved in a quick private conversation there. So
That's okay. I was more worried about the PowerPoint not working. So.
Is it okay now? Yeah, that's working, isn't it? How good are you at drawing?
Okay, if you can move to the first slide, Carly. Okay, so, yeah, as I said, the application is for full planning permission for retention of a cafe building. So the application site lies to the western side of the A128 Brentwood Road, close to the junction with the A13. The cafe is situated on the old A128 with access from a stopped-up lay-by. The application site is located on a bend in the decommissioned road and comprises the area of the building and immediate surrounding land. The site is within Greenbelt. So this is an aerial photo of the site, and the site is central. Next slide. So this plan shows the existing cafe, which is the subject of this retrospective planning application. The building has a shallow pitched roof, regular shaped windows with appearance of a semi-rural, which is considered acceptable for the area. The building is within Greenbelt, but it is considered to fall within an exception to inappropriate development, falling within paragraph 154D of the NPPF, which allows the replacement of a building provided the new building is in the same use and not materially larger than the one it replaces. So next is just a couple of photos of the building. So here's one straight on and here's one to the side. So given the length of use of the site for a cafe and the limited increase in size of the proposal from what was on the site previously, it is not considered that an objection to this proposal can be substantiated on matters of principle or detail. So to conclude, the recommendation is to approve the application for the reasons set out in paragraph 15.1 of the report. Thank you.
Thank you, Lucy. I'm just looking, we don't have any statements in pro or anti. So we'll move straight on to questions. Councillors, any questions for Lucy? Jackie?
Well, it's not a question about the application per se, but I do think it's important that the reasons the application was called in was by various people, and Councillor Rice has not been with us, has he, for years. So it's just confused me. I assume it's because it's been sitting around for a long while.
Yeah, unfortunately, it's one of the older cases that we're sort of finally completing the final few cases that are older, so that's why that name is still on there. Yeah.
Can identify at least one of the others, though.
I think it was the delay was also due to the stopping up process, which extinguishes highway use of the land. So that delayed the application by quite a long time.
Good point. Any other questions? Steve, and then Steve.
Just interested to know when were the original buildings put up? Any ideas? Anyone sort of mentioned? I mean, I remember sort of 20 years ago that it was, maybe 25 years ago that it was there, but it was 3 containers welded together, I believe, at one time.
Yeah, we've got historic aerial photos going back to 1999, and there's been something on there for a very long time. But the report notes that there was something, the previous building effectively, so I think what you were describing has been there since at least 2008. So it's because of the background history to it, because those structures have been there so long, that's the reason why it would be acceptable in this case. If somebody come forward with a cafe in the Greenbelt today for a brand new building, it wouldn't usually be acceptable. So this one is based purely on that sort of long-term use of the site, which, as you described, probably about 20 years for that previous cafe use.
Thanks, Steve. Any other questions? Oh, of course, yes. Sorry, Steve.
Can I just... Right, so I don't have an issue with the building. What I have an issue with, you've stopped up one end of the road that was the old A128 originally. But what it hasn't done is stopped vehicles coming out, so lorries coming out and going across onto the Alsop roundabout. So they're crossing 2 lanes of traffic. And you've also got vehicles that are parking where you've stopped it on the opposite side of the road there to walk, and they walk over and use it. So you have lorries that are hanging right on the edge of the road. So they're kind of dangerously parked apart from anything else. But there has to be a way of kind of, I don't know how you can do it, but when people come out of there, it's incredibly dangerous when lorries pull across, because it's on a blind bend. Someone's cut all the undergrowth down, so that makes it slightly better. but it is incredibly dangerous. I know of one lad who lost his life there when a lorry pulled out in front of him. It's probably
Thank you, Chair.
Julian, yeah.
The
Thanks.
fatality you refer to was at the section that was now closed off. The fatality was at the section that's now been closed off. The difficulty with the previous layout was that obviously vehicles could come in and go out, and they were turning right or even pulling out left, and the visibility, obviously looking back across yourself previously, was awful. And as part of the stopping up process, the gentleman who asked for the stopping up process has decided to close that entrance, which the council would have done themselves had the gentleman not done it. We have checked the visibility displays at the top junction. The gentleman has also cleared the visibility displays at that top junction to meet the national criteria for visibility displays at that location. I understand your concerns, but the actual junction of the two that was causing the problem was the lower junction, not the upper junction. So we've done what we can, or the gentleman has done what the council would have done these improvements, but the gentleman has done that himself. So from a highways point of view, we feel that what has been carried out is a lot safer than what was there before. I notice your concerns. I will have a look at the parking along the A128. I suspect there might be a clear way on there, and that's something that I'll check. And if that's the case, we'll ask our enforcement people to have a look at that, because obviously you should be parking within a clear way.
So just to pick up on that, so are we talking about in terms of what you were describing, Steve, and it might be worth bringing the map up, and particularly if we can zoom on it. So are we talking about traffic coming out, in effect, out on the northbound road off that, the northbound carriageway of the road off the Orchard Cock, coming out there and coming across the northbound to the southbound to go on to the roundabout? Is that what we're talking about?
Can we just clarify which junction has been blocked off? The northern one? So are you saying, Steve, they come to the bottom one to leave and turn left and have to do that angle? Can we not have a no left turn? They could go to the roundabout and round, couldn't they? Yes, so even that's not ideal, but it's better than, yeah.
Thank you, Chair. It's something that could be considered, but obviously it would require a TRO, and it would be something that the council would be looking for the applicant to potentially contribute to.
Yeah, the difficulty with this application is that the red line is only around the cafe building. So it is all related, but to actually require that as part of this application wouldn't be possible.
Perhaps a separate item to pick up with highways. Okay. Thank you. Any other questions? Steve.
I mean, if it's been there for 30 years, how many accidents have actually happened? Have we got any sort of recall of that?
Off the top of my head, when we looked at the closure or the stopping up, as I said, there was no accident record at the southern junction. The accident records were all at so the fatality wasn't the only accident at that northern junction. I'd have to go away and have a look at what the current accident record is. It's the stopping up was a couple of years ago that I was involved in that.
Okay, any more questions? Or should we move on to debate? So, who'd like to start? Final furlong people. Okay, Steve.
Well, from a hygiene point of view, I mean, it was 3 rusting old, trailer bits 20, 25 years ago. Now it's a brand new sort of cafe. Very handy for all of the truckers and tradesmen on their way through one way or another. As I say, it's been there for so long that I think we've got to give it the approval, personally.
Thank you, Steve. Anybody else? Roy.
Yeah, Chair, I agree with that. It's been there a long time. It's a facility that is needed for truckers and such, like we always talk about that there's not enough cafes out there for these people, so it's a facility that is needed. Yeah, I've got reservations, as Steve said, about the entrance, but at least it's a big area. The cafe's sitting there and there's big areas there for the lorries to park. It isn't like there isn't a lot of space, lorries can go in there and they can turn round, so that helps, but if we could improve that junction a little bit, that would help in future, maybe. Thank you.
Thanks, Roy. Ash was just suggesting that perhaps we could put it in, okay, even if we can't put it in as a condition, we can put it in as an informative, the no left turn.
Yep, of course, Chair, that's no problem. Is it all right for us to draft that? Yeah.
Thank you. Anybody else? No? Okay, so shall I go to the recommendation? You sure? Right, the recommendation is that the Chief Planning Officer be authorised to grant permission for the development subject to conditions. Do I have a proposer? Roy. Seconder, Steve? All those in favour? I think that's unanimous, isn't it? No? Oh, sorry. All those against? Do we have an against? If it's either there's nobody against or it's... sorry, is there an abstain? We rooted you out eventually. Right, so the recommendation is passed, and with that, I declare it is now what? Would help if I turned it the right way up. It is now 9:10 p.m. and I declare the meeting closed. Thank you.